must ingrain into ensuring that workers have their rights protected. And it was in those circumstances that the Right Excellent Grantley Herbert Evans and the Barbados Labour Party at the time saw the need and felt it necessary to ensure that the rights of workers were entrenched in this country. And I say that being cognizant of the fact that when we look at this debate this afternoon, it ought to be, in my view, humbly, done through the lens of social justice. Social justice not for a few, but social justice for all. And it is not lost on me, as I've said previously in this House since I've come before, that we're on the eve of the 400th anniversary of when Barbados, unfortunately, was colonized. We're at year 399. And I feel a sense of humility to be able to lead in this debate this afternoon, having come from a country that was unfortunately global headquarters of the British slave trade, to some 339 years later, to be speaking and leading this bill this afternoon in circumstances where only 7 weeks ago, a black young man from Barbados was the senior advisor to the first black and African Director General of the International Labour Organization. Now, Mr. President, as we take a closer look at the bill before us, the proposed legislation is really trying to make provision, and I repeat, for those here and those listening online and elsewhere, it is really about ensuring that there is a minimum threshold, minimum. So there's a floor that you cannot go below, relative to rates of pay in the first instance, and secondly, and importantly, conditions of work for employees in circumstances, and this is the important bit, Mr. President, in circumstances where concessions are granted by the state to their employers. So we're not just talking loosely here. We're talking within the confines of the rights of workers and the conditions of workers and the rates of pay of workers in circumstances where the employers, if they receive concessions from the state, what is the relationship and what is the minimum standard that we are being asked to agree to and to treat to. And therefore, the bill is modeled relative to the relationship between employers and employees. Now, taking a further step back, this was mirrored from the Labour Clauses Act, which was actually proclaimed in 1952, and closely models that of the article from the International Labour Organization, Convention 94. And the purpose of that bill is invariably to ensure that the spirit of the ILO Convention and also its attendant recommendation, Recommendation 84. So whilst there is the convention, there is a recommendation which suggests on how states ought to treat to their employees. And by states, we also mean those within the state. And to govern the relationship between the employer and the employee. Now, the Act treats to where government procures goods and services from private providers paid from the public purse. So in other words, what we're discussing and debating this afternoon is if an entity receives a concession from the state, AKA it is being funded by the taxpayer, then this debate brings that into square focus. And as such, those benefiting from taxpayer funds ought to, not maybe, not recommended, ought to treat the workers to a minimum standard. And that minimum standard is now going to move from the mode of convention and happenstance sometimes, or goodwill, now into a mode of codification where there is a guarantee for workers relative to their rights. And as I said before, these are relative to the rates of pay, and secondly, and importantly, the conditions of work. And it also seeks to ensure that as entities conduct their business, that they do so in circumstances where there's no less advantage accrued, in circumstances where one entity gains advantage over the other by way of disadvantaging their employees. Now, I want to bring recommendation 84, and I'm going through this very slowly so that we can build up and understand where we're going with this, because it's a historic day in our country, and it's a historic day relative to the laws of Barbados and the rights of workers. Now, recommendation 84 brings this cognizance into full reality, that not all who benefit from state resources do so by way of public contracts. And I want to read for you, Mr. President, and I can make this, of course, a document of the House, Clause 1 of Recommendation 84, and it says, in cases where private employers are granted subsidies or licensed to operate through a public utility, provisions substantially similar to those labor clauses in public contracts should be applied. And why do I mention this? When you look at the original convention, it focused on public contracts. But it is now the recommendation back in the 50s and 1940s, look beyond and realize that if we're going to pass this convention, there may be a time in the near future at the time, medium term or long term, that the issue is not only about public contracts, but those who receive concessions. We have to also ensure and make provision in that reality. And therefore, when you look at a subsidy, which are various funds collected from the taxpayer and given to an entity which provides assistance or support for that entity's operation. And as such, concessions, as I mentioned, are a form of subsidy, where instead of paying the tax or levies due, and followed by the receipt of allocated funds, the government permits the entity to retain the amount ordinarily required to pay. Now, last year, the rates of pay and conditions of work established here focus particularly on the construction sector and the road building sectors, giving the Chief Labor Officer the power to treat to these issues relative to the standards that we mentioned before. And this was done after significant consultation with the Barbados Employers Confederation, as well as the Barbados Workers Union. And this was done to ensure that workers in entities benefiting from public contracts in the sector were not, and I repeat, this was done to ensure that workers were not treated to a standard below what was required. In other words, that minimum threshold that I'm talking about. And the methodology used, Mr. President, looked and used at existing collective labor agreements as a baseline for the consultations that were held. And I repeat, that the methodology used in those consultations was that of the existing collective labor agreements, using that as the baseline for the consultation. And out of the bosom of those consultations came the reality, and it became very clear that entities who benefit from such concessions, as it were, benefits, whether those be financial or otherwise from the state, must adhere to a minimum set of standards for their workers in the operations of their entities. Now, this administration has ensured that it comes and continues to advance the cause of workers relative to decent work. And I'll touch on decent work a bit later. But I just want to remind us, we have the Employment Prevention of Discrimination Act 2020 under this administration, setting of national minimum wage and sectoral minimum wage, and also the Regulation to Safety and Health at Work Act. Now, Mr. President, it is incumbent that the legislation be introduced so as to guide the process of granting concessions and the establishment of the minimum acceptable terms and conditions for workers engaged by entities receiving concessions by the state. Now, this also became evident during the meetings and consultations with the stakeholders from the tourism sector. Now, here is where I want us to narrow in a bit more. Out of those consultations with the tourism stakeholders, we realized that the majority of entities in the country are doing right by workers, and I want to repeat. The majority of entities in the country, private sector companies, in the hotel sector, are doing right by workers. And in every circumstance in society, or in every mode, sometimes there are a few who are not doing what is right by the workers. But even though it is a few, the size is still too large to be ignored. And whilst the majority are in compliance with the conventions and the norms to ensure that workers are treated fairly and that they get what is due unto them, the number is too large, even though small, for there to be any ignoring of that. And therefore, a number of those entities in that small percentage left the collective, and this is important, even though small in number, a number of those entities left the collective agreement between the BHTA and the Barbers Workers Union. And that caused for some concern. But equally, not engaging with union on terms and conditions of employment, and some indicated that they wouldn't. So it caused a level of concern amongst the stakeholders. And I must admit, Mr. President, some no longer honored some of the provisions that were agreed to before. As I said, and I want to repeat, so there's no level of doubt, the majority are and were in compliance. But for those who have not been, in a 2024 Barbados, a country that has gone through the backs and the burdens of injustice, that kind of behavior is not acceptable. And therefore, we now come to look at what are the obligations. So we're talking about the bill, but what are some of the obligations, or what are the obligations rather, that we are talking about today? Now, for the entities who receive the concessions, they must maintain an employee record of wages paid to an employee. Secondly, the record should show the time that the employee has worked. Issues relative to who performs the duties connecting to the award, concessions, and the benefit thereof. Records could either be kept electronically or in another format. And the records must be available for inspection by the Chief Labor Officer under the terms of the Labor Department Act. Now, the employer must treat employees pursuant to the grant of a concession as a person insured in accordance with the National Insurance and Social Security Act. Now, relative to the rights of the employee under the bill, and as I say this, I want everyone in the sound of my voice to listen to them and to tell me if you can find anything unreasonable. And I invite you to follow, because I can almost tell you before I do that there's nothing unreasonable. Because why? These are things that have been done before, but this is simply a codification of practice. Where default in payment of wages to an employee by the employer, Mr. President, the employee may make a claim of payment of wages unpaid in accordance with an enactment for protection of wages. Now, if an employee gives you service and he or she is not paid their wage, This is simply saying they have recourse to make a claim to get what is due to them. Unreasonable? I say not. Freedom of employees to be associated and to be members of registered trade unions. No harm there at all. The recognition and the right of that recognition to bargain collectively. No trouble there at all. Now, Mr. President, the provision under the bill, when we look at the issue of recourse, provides for the Employees' Rights Tribunal to hear disputes concerning rates of pay and conditions of service, where said rates are established. Additionally, an employer whose concession has been suspended or revoked and aggrieved by the decision has recourse to the appeal to the Barbados Revenue Appeals Tribunal under the Barbados Revenue Authority Act 2024. In other words, if an entity has their concession revoked, we're not just saying it's revoked, you have a right to appeal. So even in this process, there's still a mechanism that allows for entities to have recourse to appeals. The laws of natural justice, etc., requires that everyone has a fair hearing. So built into the bill is the mechanism that if a party feels aggrieved, they have recourse. Now we should all note that where no existing or established rates and conditions of work exists, the Chief Labour Officer, and this is where the consultation comes in, shall consult with representatives of workers and employers, also establishing and publishing the rates of conditions in the official gazette. This is really the transparency mechanism, as we would call it in trade terms, or in ILO speak, as it were. Now, I want to really get, after we've gone through that initial discourse of the structure, etc., I really want us to treat this afternoon now to the issue of really what is at the core of the bill. And simply put, in layman's language, if you receive concessions from government, and I repeat, if you receive concessions from government, all the bill is saying to you is now there is a codified minimum standard that you have to adhere to relative to the rights of workers in circumstances relative to their pay and their conditions of work. I repeat, what is at the core of the bill? A codification of practices that have been going on for a very, very long time, many, many decades, saying that if you receive a concession from the state, you now have, as a minimum standard, to give the rights of workers, or there's a minimum rights of workers that you have to adhere to, that you cannot go below. So we're not asking for there to be anything new, but it is simply saying the rights of workers must be guaranteed to this minimum standards. And as I said, Mr. President, I've heard a lot of discussion in the public airways, social media, the print media, in the bars, in the buses, etc., on this bill. But I really want to say, as I started by saying, to their credit, the vast majority of private sector entities in the country, and in particular the hotels, have been compliant for a very long time. But that notwithstanding, there are a few who have not been so good to the workers. And notwithstanding that that number is small, it is too large to be ignored. And therefore, this is why we're here today. Because why? We have an obligation as a state and a country to ensure that we protect the interests of all, particularly those most vulnerable amongst us. And what are some of the examples of the lack of standards that are obtained? You had a situation, as we all know, tourism is our #1 income earner. Large profits made by entities, nothing wrong with that. Entities go into business to make profits. But whilst they're making profit, and large sums of profit sometimes, they're workers who operationalize and ensure that those profits are materialized have to go to work in the same uniform given to them 3-4 years ago? Where circumstances where the color of the uniforms have changed from the original intended color. But yet they're expected to go to work looking clean and dignified, but not being given the tools necessary to do the jobs. They also had a situation where a lot of workers are not entitled to have food. And if they can't have food provided to them, the understanding was that they will be given money to be able to go and purchase. But what I'm told, and I understand, somewhere around $7 to $8. Now we're in 2024. Can you go and leave your job for lunch and go and buy lunch for $7 or $8 or $9 or $10? Unless you're going to buy something that is not healthy. Because you're going to force people now to buy things that are not in keeping with the fight of non-communicable diseases. So therefore, it's a bigger problem. But I go on, sir. When we look at what is being proposed here, we have to ask ourselves as a country, who are we? And what minimum standards do we stand for? And what values are we going to allow our country to be known for, or continue to be known for? And I touched on it earlier, and I want to touch on it now a bit more in detail. Both in the ILO and also SDG 8, Sustainable Development Goals number 8, speaks to the issue of decent work. So in other words, we're not just talking about you have a job, so therefore you work, but there is a body of accepted international policy, as it were, that you shouldn't only be entitled to work, you are entitled to decent work. And what does that look like? The same things that you're talking about here in the bill. Decent wages and decent conditions of work. Being able to associate with a registered union. Because why? You must not only be entitled to a job, but the conditions of that job must allow you also to prosper, to thrive, to be able to earn a decent living, and to ensure that you have your dignity intact. When you walk into a job, you must not walk in and then leave feeling worse than you were before. And this is really what it is trying to achieve, that minimum threshold that we're talking about. And if I move on, Mr. President, and using the opportunity on the other side of my hat with Minister responsible for investment, I've heard some of the chatter and talk on the airwaves that this bill will scare foreign investment. And I want to put that view to rest. Nothing, and I repeat, nothing could be further from the truth. And I'll tell you why. As fate would have it, it was either on Saturday or Sunday. I received 2 calls from 2 different potential investors to the country. And they are keenly tuned in to what is taking place, not just in Barbados, but on this bill. And you know what they said? We are keen, not only because it is Barbados, and yes, Barbados has a very large global following now and profile, but your bill, and should it pass, will send a significant signal to the world that your jurisdiction is a place that we can do business with. And they went further, one in particular. And what he said is that more and more in the global boardrooms across the world, owners of companies are being driven by shareholders. Well, shareholders invariably are being driven by consumers who are conscious and want their companies to do business with ethical jurisdictions, ethical companies, and sustainable companies and jurisdictions. And therefore, this, even though that is not the intention necessarily of the bill, it therefore places Barbados in a very unique place right now to be able to say to the world that we are not only the country that is championing the issue of global social justice in climate around the world, fighting the issue of social justice around the world of financial reform through the Bridgetown Initiative. But in our own country, we are ensuring that social justice is being done for the workers who make our #1 income earner a success. And the two are not mutually exclusive. In other words, if you have a successful hotel industry, the view that passing this bill would take away the competitiveness of the industry is not true. Because why? Happy workers make successful companies. I repeat, happy workers make successful companies. And if a worker comes to work and he or she knows that their employer, through law, will provide an environment that ensures their dignity, their income, and the quality and conditions of work, the level of productivity that will happen will be unimaginable. And all we are saying is the time has now come in this country, a country that has endured, unfortunately, the scourges of colonization and the mistreatment of workers. Now is the time for us to close that gap in the right of workers. But I also want to add another point. This bill, in my view, will also add to stability in the market force and the labor force. Because why? Workers strike when they're not happy. But when there's a settled body of law and conditions that allows for them to do their job in a place where they're guaranteed those standards, you have certainty in the labor force, and you have certainty in the labor market. And therefore, for domestic businesses wanting to set up, and for foreign entities wanting to set up in Barbados, you know we'll have an even stronger environment where people can say that market is a settled labor market. You know, we like to talk sometimes about attracting foreign investment only in terms of rates and currency, etc. But we have to ensure that we also do so even more to ensure that our workers are part of that strategy of why people should come to Barbados to do business, and also why Barbadian businesses should set up here and continue to set up here. Because why? The minimum standard is what we are advancing. And as I said, it is really a question of social justice. And lastly, that view that being competitive and doing what is right are mutually exclusive, we must forever put that to rest. And Mr. President, when you think on the history that I've touched on earlier, and in the spirit of Grantley Adams and the Barbados Labour Party, all of this is taking place in a time when we have to ensure that we move the agenda forward for breaking down all inequalities. And when you look at the Labour Clauses Public Contracts Act, which was proclaimed 1 year after the right of voting for all adults in this country, years after the establishment of the Barbados Workers' Union, which he started, Grantley Adams, some 14 years after the establishment of the Labour Party, and that 52 legislation came 15 years after he represented the now Right Excellent Clement Payne, if we all remember Golden Square. Because it was those conditions, unfortunately, that caused a lot of the unrest. There are too many examples in history that we have to know, be cognizant of, that we must not allow to be repeated. And the question is, what does Barbados stand for? Who are we as a people? And as we grow the economy, and as businesses come to Barbados, and as businesses set up, and as companies enjoy significant levels of profit, and as companies continue to receive concessions from the government, and let's be clear, there's nothing wrong with concessions once you're doing the right thing. All we are simply saying is do right by the workers. But it is not only about looking back in the past on past successes and what we've done in the past for workers. This administration has and continues, and let me be clear, the Barbados Labour Party administration, since it came to office in 2018, also advanced the cause of workers even further. Mr. President, we've seen 2 public sector pay increases. And I say this in circumstances where we're under an IMF program and we've had COVID, but yet we were able to give 2 pay increases. Compare that to the period before 2018, when for 10 years, the Democratic Labour Party only gave 1 under no IMF program. But yet we were able to, under difficult set of circumstances, be able to find a resolve and manage the economy well and to ensure that workers have what is due to them. And this is at the very heart of who we are, not only as a party, but invariably as a people. We also appointed over 1,000 public officers, established the position of Customs Officer 4, and appointed 138 of them who were doing the work. We've increased the minimum non-contributory pension. We've enacted legislation to outlaw discrimination in employment. We've established a national minimum wage. You remember, I'm sure, Mr. President, a lot of the talk which suggested that the economy will crumble. Today, Barbados is standing firmer and firmer and firmer than ever before. Because why? We took the tough decision that this is what we must do to ensure that there is that minimum threshold. And not only is there that foundation, the economy is growing. You've heard the governor speak to it before. Last year, between January and September, we enjoyed 4.4% growth. And therefore, as you grow, you must not take your eyes off the lens and test of ethics, sustainability, and social justice. And in wrapping up, I want to say this, Mr. President. This debate is not about workers versus capital. This debate is not about an us and them. This is about ensuring that as Barbados continues to grow, and that as Barbados continues to be the place and choice of doing business, and that Barbados continues to be the place of ensuring that our people can prosper, we must ensure that our workers, as that success continues to grow, are guaranteed a minimum floor of which they can be guaranteed rights to pay and decent working conditions in circumstances where the employer is enjoying concessions from the government. And therefore, all of us in here, as honorable senators, have a moment in history that we can demonstrate openly for the records to reflect. And today, what is today's date? 21st. In years to come, maybe when I have grandchildren, and my grandchild looks at me and says, "Granddad, where were you on the 21st of February? And not just where was I, what was your position relative to the workers on the 21st of February 2024? And the question is simply put, were you on the side of workers or not? It is that simple. Were you on the side of workers or not? And there's no intellectualizing of social justice when it comes to doing right. And therefore, we have to ensure that today, that this debate reflects not only the current environment, but understanding the historical environment of which Barbados has come from. We are all the children of a post-independent nation. We are the children and beneficiaries of a new republic. And therefore, as we debate today, this debate is invariably one which will forever judge how we treat not only to workers today, but to our society going forward. And with those words, Mr. Speaker, I'd like to beg that this bill be read in second term.
Thank you very much, Senator Blackman. Senator Watson.
Thank you, Mr. President. Mr. President, I rise today to speak to this bill as a person who has been an employee, fortunate enough to work for a company that treated its employees well, but we also had cause to complain from time to time about our terms and conditions of work. And when I talk about employment, I've worked since I was 19 years old, doing a summer job during my university time. So I've worked for a long time. And I've worked in different circumstances. Also as a temporary employee who I suppose theoretically you could treat differently from your permanent employees. So I've confronted those issues from the time I was a teenager. But also during my employment, permanent, perhaps being a bit of a misnomer because no employment is permanent, and operating as the head of a staff negotiating, let's call it association. So the non-bargaining unit staff in the company had a staff association that negotiated terms and conditions as well. We didn't have a collective agreement, but we ensured that terms for the employees in that category were mirrored in each individual contract, and we negotiated over all manner of things. And so, as it were, you could say that I was also a union leader, because that's what we functioned at. And as a matter of fact, many of us were, and I suppose we could still say are, even if we're not financially up-to-date members, we're members of the Barbados Workers Union. And either coming up within the company or joining the workers' union. So we saw our working lives from that perspective. I've been an employer, and so I can bring that perspective to bear. I hope my employees wouldn't say that I'm one of those bad employers. I think not, because they stayed. But from time to time, they would come and say, I want to talk about this particular element of my terms and conditions, and you had to deal with that issue. But I'm also an attorney who advises businesses and advises employees. And I have advised businesses that are starting up, major businesses in this country, including Reject, for example, who needed concessions and did a lot of work interfacing with the government, and I advise that company. So I understand that perspective as well. I think it's important for the members of this chamber to understand the perspective that I take when I look at this legislation. So the second thing, because I just talked about how I developed my perspective on this, but the second thing I want to make clear is that this opposition understands and supports an intention to protect workers in Barbados. Let me just make that clear. Because I expect that there will be accusations that we are not being employee friendly, but we support the intention that appears from this legislation to make sure that workers in Barbados have decent work in this country. Where we do not agree with what we are confronting is that we are dealing with legislation that, while it appears to attempt a level of social engineering, it does it in an extremely clumsy fashion. And that, Mr. President, is where I depart from wholeheartedly supporting this legislation. And I'm going to go into detail on that. I've analyzed the legislation. I've read every single word, every single letter, number, etc. in this. And I've taken the position of, if this came to me, what would I say to my client? Whether my client is an employee or an employer. And I found that there were far too many questions that arise from this legislation that I could not give a clear answer on. And it seems to me that unless the government is simply inserting itself into what has been a public feud, using a legislative power to insert itself, or inserting itself to create membership for a specific organization, the government has not taken a clear enough approach to defining the rules that it is attempting to set down in this legislation. And that gives me trouble, because this legislation does nothing more than regulate relationships. between employee and employer and the government. And every player, employee, employer, government, the minister who grants the concession, and the minister who's responsible for labor, has to know what rules apply to them and how they go about putting these provisions into action. So that's very important. Intent, but also how you are effecting that intent. So let me address a few issues that occur to me in this legislation. I want the government members of the Senate to listen to me carefully. It's not about being combative, but there must be a certain level of sophistication brought to bear when you bring legislation to the House that allows the people who utilize that legislation to do just that, to utilize it, and not have to look behind themselves and can't be sure-footed and don't know what rules they have to apply in a real everyday context. That's what's important. And the Honorable Senator made reference to it not being an intellectual exercise, but that's what it comes across to me, because I cannot see how we can apply some of the rules that are set down here. So the first thing we need to make contact with is, what's a concession? Why would the government give a concession? Concessions are incentives. Some of the legislation actually use the term incentive. And an incentive at heart is meant to encourage an investor, a potential investor, whether that is a business coming in or even a person with some money on the bank who you're saying, put some money into a business. So you're saying to an investor, I'm going to incentivize you. And I think it's very important to understand the nature of some of the incentives that we're talking about, because we're not just talking about tax concessions. You may have reduced corporate tax, or you may have some relief from duties on equipment and vehicles and whatnot, but you also have reduced withholding tax on dividends. That's very important. Some companies benefit from that. They can pass that on to their investors. And so we're also looking at loan guarantees. That's one of the features, one of the incentives featured in the Small Business Development Act. And these are the kinds of things that we're talking about suspending or revoking when we talk about the minister's power to act under this legislation. We need to pay very close attention to that. Very important things. And so when we look at incentives and we talk about what will be removed, we have to pay attention to how it affects the business as well. Because the business exists as an economic actor, employees will benefit from the continued existence of the business. We're not talking about businesses treating employees poorly. We're talking about a due process issue, because we will find as I go on that there is a big gaping hole in the process that could have an employer facing the revocation of an incentive and then having to contend with that. Meanwhile, his business is placed in jeopardy. Now, Mr. President, there is a question as to what will happen to a business if you remove an incentive, as though it would take a very long time for a business to decide, I'm done with that. And there's a suggestion that investors will not be impacted and will not go away. But those of us in here, there may be one or two of us who may be young enough to remember, old enough to remember Intel. Some people might not. And that a concession ended by effluxion of time, and lickety split, that company was gone. And we have never been able to fill that gap in technology company operation in this country. Not that the company did something wrong, but it left because it didn't have the concessions that it relied on to run its business. So it's very important to remember that these are real practical impacts that can be had on a business if a concession is removed. And so if you go about looking to remove the concession, we have to be concerned about the process for that removal. And that's where I'm going to be colloquial. I get the heebie-jeebies when I look at the process or lack thereof that's set down in this legislation. An employee is aggrieved. We do not know how the employee communicates to the minister that they're aggrieved. The minister goes to the minister that gives the concession and says, an employee is aggrieved. And that minister that gave the concession can suspend or revoke. And in all of that, we see no rules, no process, no timelines, no mechanism. And that gives me the heebie-jeebies. And because a business person ought to know that a complaint was made. The employee actually ought to know how to make that complaint. The business has to know a complaint was made and ought to be given an opportunity to address the complaint. That is missing from this legislation. The lawyers in here know that will discomfort us. It might give us work in the end, but it will discomfort us because we want to know what is the process. Was it followed? Was there due process? Was the person who is impacted by that administrative act, because this is an administrative act, was that person according the rights that are acknowledged under a body of law that we call public law or administrative justice? This act does not, in my view, line up with the principles that drafters decades ago in Barbados had the foresight, extraordinarily, because a lot of countries haven't done it, to put down, to codify the administrative justice rules in our laws. And this law, this bill, when I line it up against that act, it does not line up. That is the point. The due process element, the natural justice element is missing. And so imagine, if you will, that a complaint is made, and the concession that it relies on, that it will rely on for a medium-term to long-term planning horizon, is swept from under them. They have to continue, however, in business. And when that concession is taken away, several things could happen. You will have an immediate tax liability, potentially, that you have to meet. You may have to pay duties. You may find that your loan guarantee is suspended, and the bank says to you, we talked about them earlier today quite a bit, the bank says to you, oh, I'm so sorry, but you don't have a guarantee, and calls in that loan. So we see, and we understand that the government wants to have an incentive, ironically, to force an employer who is inclined to be recalcitrant to act correctly in the interest of employees. However, that is a rather big stick, because when that damage is done, how does that employer recover? And if that employer cannot recover, then the employee, him or herself, is in jeopardy. Their employment is in jeopardy. So we have to balance the interests. We have to operate in a way that makes this effective and does not end up damaging all of the parties in the process. Now, Mr. President, our quarrel, therefore, is that notwithstanding the laudable intention, the execution of that intention is clumsy. I'm going to use that word clumsy throughout what I have to say, because that is the prevailing sentiment that I get when I read this legislation. Notwithstanding all of the flowery words around why the government is doing this, one does not feel comfortable with the approach that the government has taken. And in that respect, there is a suggestion that, or rather there's a repeated reference to the hotels sector and how they conduct business. I can't imagine that it is all, so we're going to say some of them. But that's not what this act is about. This act is about any business that receives a concession from the government of Barbados. That's what it's about. And that can be across sectors. In fact, there is an explicit reference to the Small Business Development Act, and if we looked at the areas of operation that are contemplated under that act, I'll just call a few: construction services, financial services, fishing, healthcare services, hotel and restaurant, yes, manufacturing, retail, personal care services, real estate, right across the economy. So potentially any employer in this country, including an individual, could be subject to the removal of incentives under this legislation. And while we will say, rightly so, if you are recalcitrant, the point is that there must be a process before you go about saying to the employer, we're going to take this thing from you. They have to have a case made out against them, a case that is understandable, a case that they can answer. That is missing from this legislation. The other thing that I am, and Mr. President, you're leaving. Mr. President, one of the issues that arises there is, depending on how the concession or the incentive is communicated to the employer, it could actually establish a property right. Embedded in a license, for example, then you have a contractual document that you can seek to enforce. In other words, sue the government to enforce. So it's not as simple as the minister can say, scratch out this employer's name, that incentive is gone. You may find yourself, and the honorable leader of the opposition made reference to this, that we have to pay attention to the impacts, the potential impacts, and put forward legislation that it makes sense. I'm going to use those simple terms. And therefore, when we talk about property rights, we talk about due process, we're talking about essentially the rule of law. And again, the legislation must comply with the rule of law. Otherwise, we're not observing the Constitution as we, legislators, are compelled to do. Now, another issue I want to segue to before I continue to address the due process issue is that we have embedded in this bill the concept of minimum salary and hours and conditions of service, conditions of work. And I ask myself, how will those be set up? Well, the Honorable Senator Blackman, spoke about the construction sector and how the Chief Labor Officer went about doing that in the absence of an agreement between the union and, well, this bill refers to an employer's rep. That's interesting to me. But, and I will say but, I like to not say but too often, but I will say but. But we have two scenarios painted here. The employer representative and the employee representative may come up with an agreement that sets a minimum standard and that applies across a sector. That's how I understand it's supposed to happen. And that also concerns me because automatically I consider the issue of freedom of association. How do two organizations that I might not belong to compel me to comply with whatever they establish, essentially for their members? And we have to be concerned about that because constitutionality is an issue. Keeping in mind that all employers are not companies. Some employers are individuals who may themselves benefit from concessions under various statutes. And so we have to keep that in mind. Ms. President, I'm sorry for pointing at you. I didn't, that's not intentional. But in addition to that, you have a step up or step down process where if there are not those bodies who are negotiating, there's the Chief Labor Officer. And I ask, what standard is the Chief Labor Officer using? So while we can point to a mechanism that was used for the construction sector, I just listed a whole heap of sectors. And is that possible to apply everywhere? So the questions that occur to me are, what is the yardstick that the Chief Labor Officer will use for a minimum standard? Who must he consult with? What information is he going to take into account? What, therefore, can employers expect for the setting of that standard? And I ask, whose business conditions will fuel the setting of the minimum standard? Are we going to pitch it at the level of the wealthy or successful or profitable business, which means, therefore, that a small business will probably struggle to meet that standard, or will we pitch it at the level of the small business and therefore set too low a bar for a profitable large business to have to satisfy? These are issues that occur to me, and I think that they have to be addressed within the legislation. In addition to that, Mr. President, going back to the issue of due process, when the bitter pill of the bitter medicine of removal of an incentive or concession is administered to this employer and you're dissatisfied, so you know nothing has happened, you get a letter within 7 days saying you've lost this incentive or it's suspended, and then you have to turn around very quickly and make an appeal to the Barbados Revenue Appeal Tribunal. I think that's what it's called. BRAT is the acronym, an unfortunate acronym. But you have to go to this tribunal, and again, no mechanism You have a time frame. 7 days is not a lot in business either, might be added, given that you actually know nothing about this complaint before you get this letter. And so you have to get yourself before this tribunal within a short space of time. And then we're asking this Revenue Appeals Tribunal to adjudicate on what is essentially a labor matter. I don't understand that. I have a level of dissonance when I read that. Because, and I say that, because the underlying issue that caused the removal of the incentive is a labor issue. And I would expect that the Revenue Authority has to look at what occurred to see if you are in breach, to then determine if it is fair for your incentive to be taken away. Therefore, we're asking that tribunal to deal with labor matters, and labor matters aren't just the list of laws that we may have on, let's say, the Labor Department's website. There is a body of common law, labor law, that will affect the interpretation of those acts and that will generally apply to terms and conditions and working conditions for employees. Therefore, we're asking a tribunal that we set up to deal with revenue issues to also adjudicate labor issues from a fact basis. We're then saying, well, if there's a dispute, and I'm not sure if the appeal condition is also a dispute, because it could be. If there's a dispute, go by the Employment Rights Tribunal. Well, those of us who have worked with the Employment Rights Tribunal must automatically say, oh, hold on a minute, hold on. That tribunal is right now under-resourced, limping along. It has no chairman, it has no regulations. We've been waiting for regulations for over 10 years. That tribunal is struggling, it has a backlog, and we're going to say, go to that tribunal to address a dispute under this legislation as well. Again, for me, that is clumsy. And it does not take into account the realities of the situation. So there you are with your incentives suspended. You have an issue that you have to take to one tribunal or another, and you also have nothing to rely on to understand if that suspension or revocation will remain in place while you are on appeal, probably lining up behind a whole heap of other people who've been waiting for years, but your incentive has been removed. And you're expected to continue to do business, roll out the same business plan that may have been reliant on that incentive. That is extremely clumsy drafting. And I refer to drafting, I don't just mean the technical elements of it, because drafters get instructions. But when the law makes it in the lower house and in here, then the people who table it have to take responsibility for whatever defects exist in that legislation. So what I say here is not about the drafters, it's about the people who have determined the policy and encoded it in the bill and have brought it before these two chambers. Clumsy drafting. And the truth is, it is going to result in my view, a chaotic situation in which employers have to function, employees have to function as well, because an employee, having made a complaint, may have a dispute. And so that employee has to understand, and their representative, how to navigate this legislation. What are the rules that are in play for them? And this legislation is silent on those matters. You can say to me that you will bring regulations. Well, let's talk about that. We practitioners know that we wait years, sometimes decades, to see regulations that are supposed to explain legislation. We heard that recently in relation to the Electric Light and Power Act. 10 years later, we can't see regulations to that act. And so it has held up a lot of the business that's supposed to occur under that act. Similarly, the Employment Rights Tribunal, I do believe I heard the Honorable Minister say, or at least I read it, that a chairman will not be appointed until regulations are concluded, but that means that the number of panels that the Employment Rights Tribunal has will automatically be reduced. That will increase their backlog because their functioning will be affected. And we've been waiting for quite a long time for those regulations to be put in place. So we can't say, oh, we'll rely on regulations. If this is urgent, and that's the sense that I am getting, then this legislation has to be made whole, H-O-L-E, because it most certainly, it has a big hole, because it most certainly is not W-H-O-L-E. The holes are glaring, they're gaping wide, and this legislation has to be tightened up. And if regulations are going to be used, which I also think is not the best drafting approach. We're talking about regulations that the bill says will be subject to negative resolution, which itself is a process. So it has to be drafted, consulted on, I presume, but at least that's what employers expect, and I expect employee representatives. And on that note, we have to keep in mind that there's not just one. There's a lot of conversation around this as though there is one employee representative in Barbados. And besides the ones that are well known, I just related that there are organizations where there are staff associations that could be affected by something such as this. So you're talking about consultation, you're talking about tabling the legislation and the period passing for it to meet the requirements for a negative resolution. Therefore, you will not have an immediate fix to the gaping holes, but everyone who it affects, employee, employer, tribunals, will have to contend with the impact of this legislation. In the meantime, serious financial and economic impacts on a business, Mr. President. Clumsy drafting. I'm very discomforted by it because as a business advisor, we want to be able to say to our clients, as an advisor of employees, we want to be able to say to our clients, this is the mechanism that applies to you. And if you're serious about that protection, then protect the employee. And that protection includes defining the process and also having a due process mechanism for the person who actually pays their salary in the end. We have to be able to balance those interests and do something that is sensible. So I am concerned about the purported urgency, but at the same time, we have a piece of legislation that leaves us with more questions than answers. Mr. President, I could go on to point out all of the holes in the legislation, but I will not. They are there. I ask the senators in this chamber to read that legislation, read it carefully, and understand that we are creating, not we, not this opposition, the government is creating a quagmire if it passes this legislation as it is. It is not that it cannot pass legislation to protect employees, but it must pass legislation that affords all of the parties due process and that will take into account the potential impacts on the operation of a business. When, I'm going to say when an incentive is removed under this legislation. And therefore, employees must be able to navigate it. When you talk about appeal, an employee may find themselves in an appeal. That's cost. That is time. Likewise for an employer. So all of these impacts need to be taken into account, and I think that there must be a more finessed way, I'm going to use that word, finessed, to deal with the issues that the government says it is trying to confront when it passes or attempts to pass this legislation. I don't say attempts, but we know it will pass. We know it will, but it will be troublesome. That is my anticipation, Mr. President. And I think the clumsiness could be avoided by careful examination of the impact, the lack of clarity, potentially constitutional issues to meet those basic requirements of legislation that I think are missing, and to consider what we're asking smaller employers, individual employers who may have incentives, for example, a returning national who may have an incentive in relation to things that they bring back into the country, or small players under the Tourism Development Act, villa owners who may employ a helper or a gardener, but they utilize their status to import things duty-free. We have to take into account that employers are not just large, not all in a particular sector, and the lowest denominator is what we have to consider because the big boys will handle it. They will have a bevy of lawyers, they will have advisors in-house, they'll be able to handle whatever this legislation might throw at them from a procedural perspective, but the small players are the ones who find it difficult to contend with this kind of regulatory burden. I say burden, not having to treat employees well. The burden I mean is having to deal with a process that might visit itself on you, and you could not have headed off because you don't know that it was happening when that person made the complaint or the minister made the decision. And so the intent is supportable, but the road to hell is paved with good intentions. And I think that this is a case where we are on the road to hell if we do not fix the holes in this legislation. It is going to create uncertainty for people who have invested and are intending to invest. I reject the idea that it will not cause concerns for people who are intending to invest. And the people who are intending to invest aren't just the people who are going to come with a big project. It's people who we're asking to take money out of the bank who may be incentivized to do so because they have a relief from withholding tax, for example. And so these are the kinds of issues that have to be taken into account. And clumsy is an unfortunate word, Mr. President, but it is appropriate because we will find, I think, in the execution of this legislation that it gets stuck. It gets stuck because nobody knows what steps to take. The complaining employee, perhaps not even the ministers, because they will have public servants who tell them, but I don't think you could do it in that way. The public servants who have to execute under this law, the tribunals who have to hear appeals and disputes, will all say, what exactly are we doing with this? And the notion that we might be asking for perfection and that perfection might be the enemy of good enough is another suggestion that I have to take contention with, because nobody's asking for perfection, but this is most certainly not good enough. I don't even think it qualifies as moderate, Mr. President. The intention is good enough, but the execution of what the government says it wishes to do is not good enough. And not asking for perfection, asking for better in drafting, clarity, all of those things that I've spoken about before, due process to be applied to every single party affected by this legislation cannot be a contentious issue for the government. That's what the government says it wants. It wants investors to be satisfied, employees to be protected, and the functionaries to be able to perform their functions. Those requirements are not adequately addressed in this legislation. And one other thing I'd like to address, and that is a suggestion that perhaps this kind of hammer can be applied to not complying with remedies awarded under the Employment Rights Act. I heard that, Mr. President, when I was visiting the other chamber during that debate, and I was taken aback because that legislation actually has an enforcement provision that allows enforcement in the same way as you would enforce a judgment in the courts. The real problem is that you have to get into the courts. And that legislation, allow me to just consider the Employment Rights Act, but it's embedded in this law, so I think that's appropriate. Because employees are on their own, they do not recover costs, they find themselves challenged to enforce that legislation. The fix isn't this. The fix is to ensure that an employee either has a process that they can navigate on their own, or if they have to get advice, because the advice is not always an attorney, that advisor's costs can be paid. I think counsel in the room would agree that that is something that has been a challenge in relation to the Employment Rights Tribunal for some time now, and I believe that that is the real challenge in relation to enforcement. Mr. President, I have tried to address the main issues. There are some others, but I think these are the key elements of this law that caused me to pause. I heard of it, I paid attention, I said, of course, yes. This is important to protect employees, and the opposition feels very strongly that employee rights are at the heart of well-being in this country, regardless of economic, social, mental well-being, the heart of it. However, we are concerned that this legislation is going to cause too much uncertainty in relation to key elements of some businesses' economic underpinnings. And we ask that the government pause, pay attention to those details, put the fixes in, and if you can't put the fixes in this legislation since it's already been passed in the lower house, put those regulations in place quickly and take the lacuna into account, the procedural issues into account when those regulations are passed. Mr. President, thank you for your attention.
Thank you very much, Senator Watson. Senator Maladu.
Thank you, Mr. President. I shall be brief. I want to thank Senator Blackman for his clear presentation on this bill before us. I am especially appreciative for the lengths that he went to point out that everyone shouldn't be painted with one brush. None of us ever want to be in that situation, and I much appreciate that he's cleared up some of what has been seen in the local media. There are rogue employers out there, and to the extent that they are, they should be dealt with. 100% agree. Well, my comments, Mr. President, is that in general, this bill, I would characterize it, sir, as saying it's a law that says you must follow other laws. And I wonder where it all ends. Do we come back sometime later on and say we have a new law that says we have to follow the law that says you have to follow some other laws? But why do I say that? And I give one small thing with this. Very small before I get to my substantive point. But for example, the second schedule of this bill in item number 6 prescribes that an employer should recognize the freedom to join a union. I've paraphrased it, but that's what it says. For me, my guiding light, and I was reminded by Senator Maynard as we exited for lunch earlier, that the guiding light that we all follow in here is the Constitution of Barbados. And the Constitution of Barbados, as it stands today, at Section 21, enshrines the right to belong to a trade union in the Constitution. I do not need another law to tell me that if you, as an employer, restrict your employees from joining a trade union, I don't need a new law to tell me that. That is the Constitution of Barbados. So please don't understand, I'm not upset about it. Maybe you are reiterating what is already in the Constitution, and that's all good by me. Mr. President, my main thing here that has me a bit confused by is, when I read this, I can't imagine that there is any reasonable person that would believe that a business in Barbados who gets concessions, gets the benefits, gets some special benefit given to them, and we'll talk a little bit later about the need for that, should then break some other law and expect to retain the concessions. That would be completely unreasonable. But it made me think, why is this necessary for us to say this? Because in my experience, we've actually seen companies who have gotten concessions, and we have failed to enforce with those companies and done anything about it when they failed to do what they were meant to do under that. They will put forward a proposal, sir, that says they're going to do A, B, and C. And that is the premise for which they are granted these concessions. And then later on, we find out that they've only done A, they did half a B, and they never even touched C at all. I agree completely, sir, that we must have teeth to be able to say, sorry, you have not fulfilled your part of the bargain, and you do not get the benefit of that concession. I think we would all agree to that. So that really leads me to what I've said to some might be a surprising turn in this debate. I want to turn to the concessions itself, sir. And what I would like to say to this chamber, to all who would hear me, is that let us think about what are these concessions. Now, in the particular bill before us, I think it is the third schedule. Bear with me, sir. I think it is the third schedule that refers to the particular laws that must be followed. That's the one that says, this is a law that tells you you must follow these 8 laws that already exist. In my opinion, if you have already been in breach of the Employment Rights Act, we should be taking action against you. Or if you are in breach of the Employment Prevention of Discrimination, we could go on. I don't think that we need a law to say that you need to follow these laws. But on the concession side of it, which is in the list, the bills for which the concessions of which you come under, which is the first schedule, sir, there are 5 of them. These are not the only concessions in Barbados, as others have pointed out. You can get a concession by being relieved of some obligation, taxes or duties or otherwise. But there are lots of other concessions in Barbados that this law does not cover. For example, sir, there are concessions related to manufacturing in general. We protect industries, garment industries, manufacturing industries. We protect, at one time, fast food industries. I throw out a few of those examples. There's any number that the honourable senators in here can refer to. So when you get the benefit from government, it's not just these 5. These are the 5 that for some reason have been targeted here. But in my opinion, any business, any employer who does not follow the law of Barbados, there should be a consequence to it. This law is saying, in its narrow form, it only addresses those businesses that get concessions. So I thought I would look back and say, well, you know, what's the reason for these concessions anyhow? And that's the troubling part, sir, that perhaps will come as somewhat of a surprise. But in thinking back over the last 10, 15 years, I cannot think of one substantial new business, one substantial new investment, whether it be in real estate, distribution, hotels, construction, shopping malls, manufacturing, marinas, golf courses, retirement villages, overseas education institutions setting up here, who have not got concessions. I'm not saying this is a bad thing, don't maybe be upset. I'm not saying it's a bad thing. I'm trying to look at the structure of our economy. Because fundamentally what we have, and concessions, sir, are used all over the world. I remember seeing a few years ago, there was, I think it was Amazon, was bidding in the United States to say where are they going to put their next big mega distribution. And New York wanted it, and North Carolina wanted it. Each state is vying for how do you get them, and they offer them concessions, tax relief, all kinds of things. So concessions as a government mechanism to encourage investment is done all over the world. But Barbados has a unique situation in this. Because unfortunately, sir, I cannot find any investment that has been made in the last 15 years that wasn't granted a concession, a large-scale investment. So, sir, maybe the time has come for us, and this bill, as the Honourable Senator has described it, very reasonable terms, maybe this is a time for us to look broadly at these concessions and recognize that fundamentally the Barbados economy is uncompetitive. In its natural state, it is uncompetitive. And the only way that we attract investment is by offering concessions. Whether it be, and as I say, these are only 5 of them that are mentioned here. 5 of these. There's the one, the CAP 67B, which has been kind of replaced with some other things, is very broad. It gives a lot of discretion. That concessions regime, sir, in itself creates uncertainty, which is a problem for Barbados. Because what it says is, we know we have an uncompetitive economy, but if you come with the right project, we will give you these concessions so that we can make it. So there is no certainty as to whether or not how you will operate within Barbados. So I want to link that comment with concessions with this actual act that's before us. Because in my opinion, this act should apply to all employers. Why would an employer want to have exemption from any of these laws that are listed here in the third schedule, were we going to give some employer an exemption from following the ERA? Are we giving an employer the exemption not to follow the Labor Department Act? Of course we're not, sir. Every employer has to follow that. So why do we need to mention it here? Is that not your role and responsibility as a business to do that anyhow? And if you don't do it, will you not be prosecuted or whatever the right word is in this context? So perhaps really what this new act is pointing out to us is that we have a fundamental problem in our economy that we need to address and make it competitive such that we don't have to go cap in hand to investors from overseas to try to make a market and make an economy competitive when it is not competitive. We actually need to review the entire competitiveness of our economy and recognize that there has not been any hotel built in Barbados in the last 15 years without the concessions. Nor has there been a shopping mall or a marina or a golf course or a villa or an education company coming from North America to set up a school down here. They all get concessions. Why not make it clear to everyone that we're open for business? And let us focus not on the concessions, but let us focus on discouraging the businesses that we do not want. Let it come to all. So, as I close on it, as I said, it might take a surprising route for you. I have concerns, and I believe that other senators will address them, those that have not been addressed already. But I would address the area where you know I go, which is in the facilitation of business. How do we grow this economy? My concern with this is that we might end up putting another level of uncertainty, which I think we should focus on removing completely from the market. So, sir, I thank you for the time, and those are my comments for today. Thank you.
Thank you very much, Senator Maladou. Senator Nichols.
Mr. President, permit me to begin my contribution to this debate with the observation that as a democratic society that has respect for the rule of law, that the law cannot rule if it cannot protect. And I have sat and listened to the contributions of the last two honorable senators who spoke, and I have discerned a similar pattern to some of the commentary that I have heard and read from other media sources at this surprising alarm at government's efforts to ensure that basic, decent standards are to be applied to businesses who receive tax concessions from the government of Barbados when they operate here. I suspect, Mr. President, that it is being misassumed that this legislation is intended to cure all the ills in the labor market. That the government is intended to bring this one omnibus piece of legislation to address all of the concerns of labor and to ensure, as they will say in other places, that we can all run down to this inexorable march to a New Jerusalem. Mr. President, I've heard the bill described as clumsy, and I consulted with the dictionary meaning of the word because I wanted to make sure that my learned colleague who spoke as the lead of the opposition in the Senate, who was very clear in her criticism of the bill. Clumsy is the way in which it was described. This is an act that makes provision for the conditions applicable to concessions granted to employers. It is not an act, as was just described, to make employers follow other acts. If you are operating a business in Barbados and have gotten a concession from the government of Barbados in the form of a tax concession or some kind of investment incentive, then this bill allows the government to remove that concession through a process identified in this legislation. And all this legislation is attempting to do is to make provisions for the conditions applicable for how concessions are to be granted. This is not a policing bill to ensure that workers' rights are supposed to be protected in a particular way, because the legislation that is mentioned in the second schedule already does that and already makes provision for holidays with pay, the Employment Rights Act, and all of the other pieces of legislation all have the legal requirements that employers must follow. What this bill says is that you cannot come to Barbados, make money, and avoid the incidences of tax remitted under the various pieces of legislation and all of the other things that you will have to be compliant with in Barbados law, benefit from these concessions at the expense of working people in this country. And Mr. President, I am standing here with the Barbados Labour Party government on this side of the issue, because I know that we are in a different political season now, and that we have to make and observe all of the dynamics that are going on and how this bill is being criticized. Mr. President, some attempt has been made to create, or I should say, conflate concession and incentive. Some attempt has also been made to conflate concession and rights. So that when the government is giving a tax concession or some benefit, that it is now a right. And in order to take away the concession, the government is now in breach of the Constitution. Mr. President, I am not being immodest, but I happen to know a little bit about the Constitution. And one of the things that I read recently in a book written by a lecturer in one of the more prestigious universities is a book called Against Constitutionalism. And he's not against the creation of a democratic society that is governed by rules, but what he is warning in his book is that the Constitution has now been used as some kind of theological document in which it is used to answer and resolve all competing disputes in a society, whether it be social, economic, cultural, or what's not. And that is coming out in this debate, Mr. President. Because what we are hearing is that the government is rushing this through because we are trying to according to what was said today, that we're trying to get members for a particular union. And that we are trying to do all these things and we are not considering the constitutional implications. Mr. President, if removing a concession as a result of being non-compliant with the laws of Barbados is unconstitutional, then what would be the legal basis for government to take taxes from people in the first place? Think about that, Mr. President. If the government is removing a concession because without the concession, you would have to pay the tax. But we're now conflating concession and right. So that the removal of the concession is an infringement on your constitutional rights. And therefore, the government is passing legislation to take away your constitutional rights, okay, again, without due process. We're hearing that. But at the same time, what would be the basis?
Mr. President,
I am not giving away, Mr. President, unless it's a point of order.
Point of order. Senator Nichols, Mr. President, is incorrectly suggesting that statements were made conflating a concession being taken away with a constitutional right being taken away. That is not what was said, certainly not by me. there was only one other speaker, and I do not recall Senator Malalu, but he can speak for himself, making that suggestion. The suggestion was, to be clear, that a right could be granted in such a manner that it is embedded in an enforceable contract. The reference to constitutional rights made by me was in relation to freedom of association and constitutionality generally of legislation. Thank you, Mr. President.
Thank you, Senator Watson. Please proceed, Senator.
Mr. President, I was not making any point in relation to anything Senator Watson said, and she can rest assured that when I am referring to what she said, I will let her know. Mr. President, the argument has been made in the country that the taking away of concessions tramples on people's constitutional rights. And I'm making the point, Mr. President, that if taking away a concession which would otherwise, or I should say hitherto, the taxpayer would be required to pay these taxes, then what would be the basis of taking tax in the first place? If money in the hands of a business is property, at the time of the assessment of tax, it will have to be property at the time of the withdrawal of the concession. But they are making this constitutional argument to bamboozle people, Mr. President. Because the very Constitution of Barbados, which speaks to property rights, in Section 16 of our Constitution, and if I may just be permitted, Mr. President, with your indulgence, Section 16 of the Constitution, and I'm saying this because there are people who are creating the political narratives and they are blowing the dog whistles, that the government is there interfering with your constitutional rights bit by bit. This Constitution of Barbados has provision for the protection from deprivation of property. No property of any description shall be compulsory taken or possession of, and no interest in or right over property or any description shall be compulsory required, except by or under authority of a written law. And what is interesting, Mr. President, is that, we have this view that once the Constitution establishes a right, that the right is absolute, that there can be no derogation, deviation, or abrogation of that right. The Constitution also provides for exceptions to rights. And I heard, Mr. President, the argument being made that we are on dangerous constitutional ground, but the dog whistle is being blown. And you have to call it out because they are using the Constitution as a theological weapon against this government to create a narrative that we are trampling on people's rights. The very Constitution of Barbados provides an exception because were it not so, the government could not tax in the first place. If the right to property was as absolute as was being contended, then the government could not tax. The government would not be able to take away your property. But what we have is the innocency of the workers being misused and people in Barbados being misused by political operatives who cannot come to support this government in doing what is right. All of us who practice law and represent working people know about the errant employers in the various sectors across Barbados. What, therefore, can be the moral justification of a business coming into this country being assessed a tax like every other person in this country, whether a person, a human being, or a business? But they apply and get a concession, they come and bring their business, and they can only make money at the expense of the workers of this country. What can be the moral imperative to oppose a government that intends to say, look, if you are not agreeing to a basic level of working standards for people, all workers and the people of Barbados will not be the bargain basement opportunity for you to rake in millions of dollars in cash, not pay the taxes that are accessible, and go along with your business. That is where we are, Mr. President. This bill has nothing to do about trying to police the other pieces of legislation. All the government is saying here is that if you come into this country and you cannot grant to workers the rights that are already there in existing law, you cannot benefit from tax concessions. What is a concession? Mr. President, a concession is defined in the Act to speak to at Section 2. It includes an exemption, waiver, or remit of tax under an enactment settled in the schedule, or a benefit granted to an employer having received an approval of the status of the employer as an approved entity as defined in the enactment, or the status of an improved product or approved project as defined in an enactment, or the status referred to in the following subparagraphs. So the Act narrowly defines what is a concession, but we know what a concession is, Mr. President. It is a reduction made by government in the amount of a tax that is assessed to a particular group of people. They would ordinarily have to pay this tax, but the concession is granted as a means to incentivize them into some kind of activity that would benefit the country and the people. But we are saying here, you can't come to Barbados and benefit from tax relief at the expense of working people. What is wrong with that? And all we are having is these debates to take the legislation and say that it has holes in it. But what are the holes? Mr. President, I heard Senator Watson, and I'm sorry that she's left her seat because I'm now coming to her, speak to the fact that an employer must know when an employee is complaining about some breach of the law. That is a reasonable statement. You can't fault that. But it is not for this piece of legislation. The employee does not make complaints under this piece of legislation. This legislation is an interface between government and the taxpayer. The adjudgment of wrong under another piece of legislation happens under the methodology settled in those pieces of legislation. Within the Holidays with Pay Act, the Employment Rights Act, and all the other legislation that is mentioned here have their own internal mechanism to deal with default. All of them, I should say most of them, if not all, start with the Chief Labor Officer. And the Chief Labor Officer notifies employers in Barbados almost immediately when there is a complaint of a breach of the laws, employment laws of this land. So that to come to this legislation and say it does not have the procedural mechanism to notify the employer would be unfair, and therefore the system of due process is not being followed because the government is now going to be moving to remove a concession and the employer is doing this for the first time. This act does not police the operation of the legislation mentioned in the second schedule. The act creates a mechanism for government to remove the concession in a manner that requires all it can see is due process here. So there is a conflation and a confusion being created. And this contortion that the act is deficient because nobody knows what is going on when the government starts the exercise of determining whether a concession should be removed. The concession will be removed when a determination is made under this act. But the fault doesn't generate any action, or it doesn't originate, I should say, any action under this piece of legislation. Now, Mr. President, you could well imagine an employer who is brought before the tribunal, Employment Rights Tribunal, with a complaint that there is some sexual harassment by senior management against female employees. We see that all the time. Senator Boyce will tell you we see that all the time. It is rampant across the country. How many cases have the tribunal dealt with sexual harassment? Not one. Why? Because the system is such that women in this country are working in terror. I can't talk because if I talk, I will be able to identify victims, Mr. President, because this society is so small. But only 2 weeks ago, Mr. President, I had to walk away from a client that I have known for a long time and asked my senior in Chambers to see her on the matter because I couldn't even deal with what she was telling me. Working at a hotel in this country. Subject to the and up to now, we had to write to the police to ask them why have they not brought criminal charges against this man. A repeat offender, everybody across the sector know. This is what people have to deal with in this country. And all this legislation is saying to you, if you are an employer, if it happened once, I doubt very much due process could require that the government takes away a multi-million-dollar tax concession because a manager interfered with a woman wrongfully. But if you are an employer and that situation occurs repeatedly and repeatedly and repeatedly, and you're doing nothing about it, tell me, Mr. President, what do we do in a good society? This is about people, Mr. President. This is about honoring the dignity of the human person. Barbados is not a bargain basement place where you can come in and there is cheap labor that you can unfair us like a pack of fools, and the government is compliant because according to every airport, every hotel, every this, every that is built by incentives. Everybody can come at the expense of our sisters, or mothers, or aunts, or brothers, or nephews, or sons. That they have to subject themselves. There is a particular hotelier in this country with tax concessions going on, Mr. President, I believe longer than I will be alive. That is singly the worst employer in Barbados today. And that is my opinion. Most disgraceful in the way they treat workers. And every lawyer in this country knows who I'm speaking of. Don't waste any time going to any meetings, because your client not going to get any fair hearing. But that is what we have to contend with. And Senator Watson is correct, Mr. President. The tribunal system and the employment rights system is bogged down. It's not bogged down because of any failings of the government. I stood here long ago when Senator Sir Roy Trotman sat where Senator Nurse sits now and called for, Senator Parrish will remember, an industrial court in this country. And when I got downstairs, he told me, look, no, young Nichols, your great uncle's beef and bodyguard were vanguards in the Barbados Workers Union, and they will be upset that you're trying to upset the whole process of collective bargaining and so forth. Well, Senator Malou spoke about collective bargaining. But you know that the Constitution of Barbados creates a right under the freedom of association to join a trade union. But we have had a consistent interpretation of those rights in such a narrow way that it does not include collective bargaining. So much so that when the late Justice of Appeal, Mr. Jefferson Cumberbatch, writing on the QT Lynch decision, when the last government sent home hundreds of workers from the NCC, neither the Barbados Workers Union nor the National Union of Public Workers were recognized by a government institution. And he wrote in response to the decision of the tribunal that the time has long come for collective bargaining to be recognized in the laws of Barbados. We have government agencies and the private sector as well telling trades unions that they are not recognizing the unions as the representative of workers. this happens in this country. And it happens more so in the private sector, Mr. President, because the workers there are not as organized, because there is no moral suasion that can move some of the private sector employers in this country into action. The government is always embarrassing. Actually, the government has to correct it, and most of the time it does. And another criticism I'm hearing about this legislation is that the consultation process did not involve the other unions. Which trade union or staff association representing public workers gets a concession from government to operate? I don't expect the National Union of Public Workers to make the same contribution on this matter because it doesn't interface with an employer that obtains a concession. But the employer that they interface with is the grantor of the concession. But this false narrative, again, is made for malevolent political purposes. And we have to call them out for when they are, because people will hear these things and start to say 1 and 1 is 2 and 2 plus 1 is 3 and start to create a false narrative that feeds into the refashioning and the reshaping of a moribund political system that is seeking to grasp for dear life because of recent political happenings. That is what is going on in this debate, Mr. President. So I have come to the debate, and I sat and I listened to the criticisms for the last couple of weeks on the debate. A simple piece of legislation. The Barbados Revenue Appeals Tribunal makes a fundamental determination in relation to whether a concession granted by the government of Barbados should be removed. The government is not taking away this concession willy-nilly, arbitrarily, or without any process. I understand that we want rules. I agree that rules should come. And I said to the Honorable Leader of the Senate only this morning that sometimes I believe that in addition to regulations, it is necessary for the executive in the government to issue directions on policy matters to determine or to give color as to the legislative and parliamentary intent of the legislation, so that persons who operate under the legislation are not free to make an arbitrary decision as to what is and what is not intended by the legislation. And that happens in regularly organized systems where executive direction is given. And the policy might change, Mr. President. And when the policy changes, the executive directives change accordingly. And that perhaps may be necessary, but it cannot be a situation where an employer is claiming that if there are several breaches of the legislation protecting workers' rights going back from the 1950s, Mr. President, operating in this country, collective bargaining agreements in sectors that have gone back for several years to secure the basic standards of working people. An employer is not going to hear for the first time that managers are not allowed to take part of the service charge. So to create the impression that these standards that are being regularized and the government is using the heavy hand to legislate them, the government has to use the heavy hand to legislate when there is no urgency to recognize that people require and deserve decent work in this land. So, Mr. President, as I close, I want to assure you that this bill, when it comes into law, the Labor Clauses Concessions Act, is not an act intended, Mr. President, to be utilized by employees when they have grievances with their employers. The grievances that they will have with their employers will come under the other pieces of legislation that already secures the legal relationship that has to ensue between employer and employee. The Labor Clauses Concessions Act 2024 creates a mechanism for the government to make a determination through a process that if you are not meeting the minimum standards to allow workers to enjoy decent life and work in this country, then you cannot benefit from those taxations. Mr. President, that is all. That is all. That is all. I am obliged to you, sir.
Thank you very much, Senator Nichols. Any more speakers? Senator Walters.
Thank you, sir. I wish to start my contribution by acknowledging and reiterating Senator Watson's comments that the Democratic Labour Party is very much respectful of the rights of workers and supportive of those rights of workers. And as I go down in my presentation, sir, you would see what I mean as I come to those areas. I also want to say that I myself, as a young boy, I understand what the workers in the entire industry are going through if they themselves are not getting their just due. Because I lived in a household, sir, that in which my mother worked in the industry for many years, and I know the impact of tips and service charge and all those things and how that means, what that means to a household, sir. So we are not aloof to the realities of those few employers, as Senator Blackman has alluded to. But, sir, I'm not a lawyer, and I will not challenge Senator Nichols or any other senators in their submissions of what is lawful or not. What I am concerned about, sir, is what I would say, the political posturing of the Barbados Labour Party when it comes to this bill, sir. Because last week, in the other place, sir, I listened to contributions from the ministers in that chamber, and I heard the references to the Barbados Workers Union being made. I saw the attendance of those in the union. I also heard comments like it's a watershed moment in the history of labor in Barbados. And even today, Senator Blackman has said it's going to be a historic day for workers. They're saying, sir, it's a historic day for workers. But, sir, in more ways than one, Senator Nichols, yes, threw that out to sea. The clauses in this bill, sir, 8 clauses are in this bill. And when we review the clauses, you will see, sir, that it is warm over soup, sir, as it relates to labor legislation and representation for the workers. It has been made clear, sir, that this bill is going to govern really the subsidy bills in it that are going to trigger the legislation, sir. And let me clarify what I mean, sir. Clauses 1 and 3, sir, are already contained in the Labor Clauses Act, Cap 349. Clause 4, sir, is in section 7, sir, of the Section 7, sir, of the Labor Department Act, sir. Clause 5, sir, is laid out in the NAS Act Cap 47. Clause 6 in the Employment Prevention of Discrimination Act, sir. Clause 7, the right is provided by the Protection of Wages Act. Sir, I'm just making the point that from an employee perspective, there is nothing new for the employee, sir. But there is something new for the employer. So I am drawing this analogy so to let you know that the grandstanding about the historic day for the workers, sir, is not representative in this legislation because workers have already been represented in previous acts, sir. And if I refer to Senator Malalu, who was wondering why this legislation does not cast a wider net, that is why, sir, because there is already coverage in all these areas and other pieces of legislation that covers employees. So this notion that they are bringing there's a watershed moment in the history of labor, is not for the right of employees, sir. Sir, let me refer to my memory and an article that expressed the view of workers in this country. And a recent article, sir, and it said that employees are not happy and that they're saying that labor unions must prioritize workers' interests over political affiliation, sir. It expressed the view that labor unions should be
Sorry, from what do you quote?
I'm not quoting, sir. I'm just referring to something that was in the media.
You said you refer to an article, but you're not quoting.
No,
Okay,
I'm not quoting.
that's not clear. You can reference, but you can't quote.
Right. So it expressed the view, sir, that labor unions should be independent of political affiliations. And it also, sir, highlighted that there's a union there, sir, that has tenure in this country that is losing ground, sir, and that more employees are choosing to go in an alternative union than in this union that has tenure, sir. But why do I say that, sir? Or why do I bring this to your attention? Because, sir, employees in this country, sir, have a freedom of association. And that includes, sir, having a choice to be a part of a union, to be representative of a union, sir. But the challenge that the employees have, sir, is that they seem to be locked in to the union, so they do not have a choice. They really do not have a choice. They have a choice to associate with who is there. And, sir, I think this brings the opportunity for us to look at what we have in the labor landscape, sir, to allow employees to have the freedom to choose in terms of the union representation. And this is what I mean, sir. Once a union is the chosen representative of an organization, sir, in the early days, it might enjoy 71% of the employee staff complement. But over, say, a 10-year, 15-year period, you might have maybe 12% of that complement. But there's no structured system, sir, where the employees that are now in the position to seek representation can, what we say, decertify and have a choice of the representation that they might now require, sir. It is very difficult.
Mr. President, sorry, on a point of order.
I
as far
want
as
to
I'm-
rise.
On a point of order, Mr. President, as far as I'm aware, in relation to the Industrial Relations Act and also on the collective bargaining agreements that are in place, there is a process that allows for and is arbitrated by the Chief Labor Officer to be able to go into an organization and to request that there be account of the representation. There is a threshold that is set, Mr. President, so that a union can be established as representing those workers. So I am not clear or sure, and I don't think that this is the intent of the senator to mislead the House. But those are the facts in relation to how, Mr. President, you establish representation that workers can have a choice. To say otherwise, Mr. President, makes a mockery of the trajectory for trade unionism in this country.
Thank you for your elucidation, Senator. Senator Walters.
Yes, sir. So, sir, as I was saying, I believe that the challenge that we are having here, sir, is that there is this notion that the Barbados Labour Party is going above and beyond to offer representation that is not being offered to the workers of this country, sir. And as I said, if you look at the third schedule, sir, as set out in the bill, sir, you will see that maybe, sir, they are trying themselves to become relevant as it relates to putting life, impacting labor law on the books during this administration, sir. And if you refer to the third schedule, the Employment Rights Act 2012, the Employment for Sexual Harassment Prevention Act 2017, Safety and Health at Work Act 2017, sir, and the Shops Act, sir, were all labor legislation, labor law done in the previous Democratic Labour Party administration, sir. Which, Lord, sir, shows that we do have the intent of the workers, sir. And it is so much so now that this Labour Party, sir, has now to depend on those pieces of legislation to support or to enforce persons that may not be following or treating the employees well, sir. But, sir, Senator Blackman also made a reference to the work that his government is doing, sir, in the civil service. He spoke about appointments, etc., sir. But there's also a worrying trend because growing up, you would hear, you practice what you preach, sir. But there are also instances where, sir, we are seeing workers in the public sector or working in the service not being treated fairly, sir. But the use of contracts, sir, which will not allow them to be able to obtain even a sick leave benefit, sir. They will not get, sir, the opportunity, sir, to have that dignity as well, to be able to even get a job letter, sir, to go and advance the livelihood of their family, sir. Sir, it is no doubt or is no secret, sir, that I seek to represent people. And I face a lot of calls daily, sir, of persons who are employees in the civil service who have been complaining about different treatments across different ministries, sir. And I only raise it because Senator Blackman took me there as I get trying to insist that this government is doing all that it can do for the workers, sir. And that it is the best thing since sliced bread, as they say, sir. But the reality is, sir, is that the livelihoods of people, the livelihoods, sir, of our workers under this administration within civil service, you've heard about the treatment of the ASH workers, sir. You've heard about the treatment of the school monitors, sir. And it goes on. And we have a situation, sir, where lots of workers are still under those type of arrangements, sir, and not getting their just due. Sir,
Let me hear the
Mr.
Senator.
President,
Let me hear the Senator,
Mr.
please.
President, Mr. President, before the Honorable Senator puts on his landing
Oh,
gear,
you're right, Senator
a
Nichols.
point of order, Mr. President. The Honorable Senator he said last week he may make some mistakes, but I think he's misleading the chamber because the ASH workers in this country were not government employees. They were persons brought on for a specific project. The project had a lifetime. And to suggest that the government is unfairing these people when the contracts came to an end, and in most cases, a lot of them have already been re-engaged or are in the process of being re-engaged for different projects. So to say that the government has treated as workers who are still waiting for the just due is to mislead this chamber. And the Honorable Senator cannot do that, Mr. President.
Thank you very much, Senator Nichols. Yes, we're indeed temporary workers. ASH is a temporary problem. Please continue, Senator Walters.
sir, there has been thank you, sir. There has been a lot of dispute around those type of arrangements, sir, that seem to be very popular with this government. But, sir, I wish to wrap up, sir, by saying that the kind of position that the government has holding as it relates to their mouthings of this historic day in the Day of Labor for employees, sir, is really just, sir, talk. Because as I said, sir, they are relying on previous legislation, sir, that are in place and that protects the workers in different various forms. And as I identify, sir, in the labor clauses, you can see that the different labor clauses that are captured here are already captured in the existing legislation, sir. So I end by saying, sir, if a company wants to come here and qualifies for concessions, sir, and do not treat their workers correct, sir, we do not agree with that. But please do not, sir, allow the Honorable Chamber and the people of Barbados to feel like pawns in the game, employees feel like pawns, to make them feel that you're doing all so much for them, when in matter of fact, sir, you are just putting a situation where that they already are protected, and you're just using this current legislation to enforce this particular act, sir. I thank you.
Thank you very much, Senator Walters. Senator Reverend Morris.
Thank you very much, Mr. President. I was waiting for Senator Walters to begin, but he never began.
Senator Reverend Morris, before you get into full strike, just hold a moment, please. The Deputy President will take the chair for a moment.
Reverend Senator Morris, please.
Thank you, Madam Deputy. I said that I was waiting for Senator Walters to begin, but he never began. And what little he said, sir, confused me a little, because he talked about the Holiday Repairs Act, he talked about all sorts of things that the Barbados Labour Party has done, ignoring that the Democratic Labour Party repealed the Holiday with Pay Act and replaced it with a new act. The only problem with that act, sir, sorry, madam, was that the act was the same act that was brought to the House and passed and was legislated by the right excellent Sir Granny Adams back in 1951.
So they can clear ownership.
So that is what happened.
Same identical.
Let me say, madam, that something went wrong today, or somebody has misunderstood this piece of legislation. I have been a teacher for a number of years, and currently I am the chief examiner for the Caribbean Examination Advanced Proficiency Exam in history. So let me put this whole thing into context, because I'm hearing about concessions, I'm hearing about employers. If I had to shape this in a question for the benefit of Senator Walters and Senator Watson, this is the question that I would give. Explain the reasons for the introduction or the enactment of the Labor Clause Amendment Bill of 2024. Sir, this had nothing to do with concessions. This is about protecting the rights of workers of the laboring class. This has to do with treating the workers in this country with dignity and respect. And you may ask me why I would support this, but let me go back in history, madam. Let me go back in history. Because I speak with a certain degree of passion in this place. Is it not a historical moment? Yes, it is. And why is it a historical moment? So we all know that Africans were brought to this region to work or to slave on the plantations in the Caribbean. We all know that. We also know that there were the Spanish, and I have to give you a lesson in history so you can understand this act. So there were three types of colonizers in the European colonizers, maybe more, but I'm going to emphasize three. The Spanish, the French, and the British. The Spanish, when they colonized the Caribbean, exported their law, to these colonies. Embedded in the Spanish law was a code called Las Siete Partidas. That was the slave code that was passed on to the Spanish territories. In the French territories, France exported its law to its territories. That law was called the Code Noir. It was a slave law. But as far as the British were concerned, slavery had been outlawed in Britain since the 12th century, and they had no slave code to impose on its colonies, and each colony had to create its own slave laws. And Barbados was the first colony to create slave laws. They were the most brutal slave laws, and every other country in the Caribbean copied the Barbados slave laws and the treatment of slavery. You ask me why I see this as a historic moment? Because this very parliament was used to create the same laws that brutalize black people. And I say that deliberately. This was the same parliament, or the concept of it, that created the laws to brutalize the laboring class. Why it is historic? Because I stand here and I feel proud today that I am part of a legislature that is going to pass a law securing the dignity and respect for the laboring class. That, in my view, is historic. We have moved from one side of history to the other, where a parliament was used to protect the rights of the employing class, to protecting the rights of the employees. That is why I stand here, and that is why I am proud to be part of this legislation. But you ask me why I support this? Not because of concessions, but shouldn't I support any legislation that attempts to treat workers with dignity and respect. Shouldn't I do that? Man, look, what I've heard so far coming from the newly found and formed opposition is that they are still in the process of not protecting the rights of individuals, especially the laboring class. All of them that spoke from the perspective of the employer. I am speaking from the perspective of the workers. And I'll tell you why soon. We know how these people were treated during slavery. And after slavery, the conditions did not change for the black people in the Caribbean, especially Barbados. And that whatever laws were passed by this parliament, they were passed to protect a particular interest. They were not passed to protect workers. As a matter of fact, what we had then was a lot of industrial activity by the laboring class because they were not protected by any legislation. If you live on a tenantry, you had to work on that plantation. You had no rights. Wages, sir, the thing that we are talking about, wages were used at the discretion of the employers at that time. And what happened then, sir, madam? Came the Confederation crisis in 1876 because the workers were not prepared to take it. And let me say this also, that throughout the history of Barbados, you will see these demonstrations. And why? Because slavery is something that happened to people, but they never allowed themselves to be defined by slavery. Poverty is something that happened to people, but they never allowed themselves to be defined by poverty.
Thank you for pausing, Senator Morrisseau. The President is returning to the chamber.
Please continue, Senator Reverend Morris.
Yes, sir. Even when John Pope Hennessy came in 1876, he himself lamented the laboring class, the state of the laboring class. Even attempts at migration were blocked for these workers. Then you had the Masters and Servants Act. Everywhere we turn, we see attempts to restrict the working class in this country. There was conflict between planters and workers, sir. Then you had the Depression riots in 1895 in Boscobel. They started in Boscobel and Wanstead plantations. You know, being in the north normally set the standards for these things. There was hunger, and this led to the potato riots. These led to the potato riots. And why were there potato riots? You know, people went and raided the potato fields at night. Sir, I am not going to call it the modern word. All I'm saying that these workers resorted to nocturnal activities in the fields. That's all I will say. However you turn, you saw workers being pilloried. But something changed. There was a man called Brantley Adams. He too used this legislature to change the course of history. That is why, sir, today is an historic moment. Formed after 1937, the Workers' Union. Out of the Workers' Union came the Barbados Labour Party. Sorry, the Barbados Labour Party, and then the Workers' Union. And this is going to pay it again to that myth that goes around. that the Democratic Labour Party is for workers and the Barbados Labour Party is for the merchant planter class. That is far from the truth, because this party, sir, was the party that started the Union for Workers. And the Barbados Labour Party and the Democratic Labour Party itself was not started by the laboring class. It was started by the planter and merchant class to protect the interests of capital. The only problem then, they had no leader. They had no leader. And that is when the right, and sir, you can read the minutes in Unity House, because these are issues that have not been told. You can read the minutes, some minutes in Unity House. When Sir Grandy Adams had already touted Araba as a new leader, but he was being coaxed by the founders of the Democratic Labour Party. And when he turned up to a meeting of the Barbados Labour Party, he and another gentleman, Grandy Adams told him they weren't welcome. These are the minutes, sir. When we look at the history of all of this, we ask ourselves the question, who really stands for the workers? The ones who say that we are for workers, or the ones who show that they are for workers? I have to speak about my own experiences. I watched the people, the workers of Black Bass and Mangrove, going to the plantations, walking through grass fields on mornings in the wet dew. No amenities at all. And they're working from can't see in the morning till can't see at night. Nothing to protect them. I witnessed my grandmother working, and I heard Senator Watson last week talk about her grandmother. Well, we have something in common, because we both have grandmothers that may have impacted our lives. But I witnessed my grandmother working in a cane field, weeding, and sometimes the canes are way above her head, past her, taller than her, and she alone was in that cane field. And sometimes she would take me to work with her. And when I got sleepy, she would make a trash bed and put me to lie there. But you imagine a woman in a cane field, 5 acres, by herself? And then one day, she fell, and she hit her knee on a massive, half a board, I can say. She got up, limping to the plantation manager, and he said, "Miss Morris, we're going to go home tonight, rub it." My grandmother, next day, had to go to the doctor. No sick leave. No sick leave. Had to go to the doctor. Those of you who are old enough will know that there was a doctor in Retreat St. Peter called Dr. Rogers. And she went to Dr. Rogers, and Dr. Rogers said to her, "Miss Morris, this knee is going to take you to your grave." That's what he said. It did. Where was the protection for these workers? This issue here is not about concessions. It is about workers. What is wrong, sir? We're seeing to it that workers, and I keep saying this in this country, hotel workers, all sorts of workers, exist with dignity and respect. I heard the president of the Barbados Private Sector Association saying it is going to cause people not to invest. I've been hearing many things, you know what? Even today, I've heard many things, but nobody showed me how. In fact, what is it that led to your conclusion? If, according to the Barbados, the president of Barbados Private Sector Association. Her argument is that many people are observing it, and there are only a few. Now, that is very, very inconsistent. Now, if you're saying that most are doing it, but only a few, deal with the few. But then next week, those who are doing it may change and not observe the rights of the workers. So what we do, we put regulations in place that govern everyone. All we have to do is follow the legislation. Treat people with respect. Every year, we hear about millions of profits by businesses, by hotels. Even when things go badly, they are still making their profits. And these profits are made off the backs of the workers. Every year we hear how well they are doing. But a lot of these workers are still in the same position. Hoteliers talk about how good the season was. Sometimes the only compensation some of them get is a Christmas party once persons are in a good mood. We all talk, sir, about concessions. We all talk about a Barbados Labour Party and what they did. The evidence is there. But let me tell you something, Mr. President. Let us be real. One commentator describes this as dictatorship. That is what was described. That a dictator government is putting these things in place. Let me tell you what is dictatorship, sir, and what dictators do. Because dictators come like a thief in the night and overthrow governments. They would leave a party without even having the decency to say to the party, I'm leaving. And you go to another party, and you join that party, and you cause all sorts of confusion, and you take over the leadership. That is how dictators operate. I thought you were speaking, sir. Now, that is how dictators operate, sir.
Senator Reverend Morris,
Yes, sir.
I will caution you not to go close to impugning the character or reputation of members of either house. It's against our standing orders. You will want to withdraw the reference to dictator and move forward.
Okay, sir. I will. But, sir, what we have seen recently is a reenactment of that satirical marriage between Stalin and Hitler. Is that what it is, sir? Good. But that's what we've seen recently. That's what we are seeing here now. We have to deal with these issues. This legislation deals with the workers, not with concessions. And if I open, so you grew up in a situation where your parents were told, if you don't do this, that will happen. For the first time, so I heard that concessions was a constitutional right was sometime last week or whenever it was. That's the first thing. Sir, I know that my grandmother looks down on me today. She's looking down on me now. And she is saying, my grandboy, I am so proud of you because you're standing on the side of the workers. She must be smiling to see that I am part of a legislature that will pass legislation for the betterment of persons in this country. And I can hear her saying, I'm so happy that you have not betrayed our people. She must be saying, grandboy, I told you that you were going to make it. also believe, sir, that I have a sister in Winnipeg who is now beaten to death because she realizes that I'm supporting the laborers in this country. I believe, sir, that what this bill concerns is the very nature of humanity. That laboring classes, that individuals be treated with dignity and respect. There is in our society the presence of one segment of our society thriving upon the labor of another. And this goes back as far as one chooses to look. Even as far back as biblical times. This is borne out by history. Even in the Garden of Eden, one person was pronounced superior to the other. There were times when people said that there was nothing sinful or immoral about slavery. But there must be something sinful and immoral if we are not going to treat our workers with dignity and respect. I differ from the view that says because of the competitive nature that there must be oppression. Grantley Adams, to a lesser extent, Errol Barrow, Tom Adams, Harold St. John, Erskine Sandiford, Owen Arthur. We can turn to these, our ancestors of these parliamentary chambers, for guidance on this bill. And we should not be afraid. In fact, the opposition should not be afraid of what they will hear. They should not be afraid of this piece of legislation. The strength of these leaders should help us to overcome our fears. And that strength is needed right now. This strength should give us the courage to do what is right. If fighting for the dignity of workers is going to cause protests and call for a government to resign and call for fresh elections, then let it come. And when it comes, may it be the last battle of what it means to be truly a republic. I'm obliged to you, Mr. President.
Thank you very much, Senator Reverend Morris. Speakers, Senator Kevin Boyce.
Mr. President, thank you. I had again do, Mr. President. I sat down and I have been thoroughly impressed by the enthusiasm which is set out this afternoon. I think also, sir, it's a bit of a comfort to the independent senators that the government side now has a direction to focus their ire, if there's any. And perhaps that may seem why things take a certain turn. But I believe, sir, that the debate today, if I were to give a synopsis, as opposed to a question that set out by the former speaker, Senator Morris, would be that it can be encapsulated in a statement that the bedfellows don't seem to be green. We have a situation, sir, when we examine the comments in the media and within these chambers and within the other place, sir, that there seems to be a divergence. And what I would like to propose, as always in a very moderate manner, is how we can come to an ad item perspective. So I'll do so first by setting out what I call the different perspectives and trying to encapsulate them as simple a narrative as possible for the purpose of this exercise. We have, sir, a statement by the BPSA, let's call that the private sector, where their stated concerns were the period of consultation for the legislation, the powers granted to the minister with regard to the width and the strength of those powers, and the previous delays in getting regulations drafted. We have seen, sir, the statements in the press with regard to the union and why the legislation is necessary for the protection of the workers. We have heard today, sir, and in the other place, the opposition stating its concerns about the drafting, the heavy-handedness of the powers, and of course, that the purpose is to give support for a union. There's also been statements with regard to an alleged erosion of rights. The government, for its part, has stated that this is a historic moment. If I were nitpicking, sir, I would say that it wouldn't be historic presently, but hopefully in the future it may be viewed as a historic moment. But that would be nitpicking, sir. The government has stipulated that it is necessary to protect the interests of workers. It has set out that it is necessary because of some employers who do not do what they ought to do. It has said clearly that this is not an erosion of rights. At best, as elucidated by Senator Nichols, a removal of a conditional benefit akin to grant and a removal in a taxation concept. I wouldn't say where I land, sir, on the issue of whether it's an erosion of a right or is a taxation or akin. But I think, sir, that by doing so, we recognize that we have a divergence of opinion. However, everyone and all these speakers and everyone out there seems to be saying that we are for the workers. There's no doubt as to everyone seeking to manifest that they are the ones who are representing and seeking to act in the best interest of the workers. So I think that is where we can find the agreement, Mr. President. Now, sir, for my part, the independent perspective, Mr. President, I think what we need to recognize is that we are seeing here members of our much vaunted social partnership having some elements of disharmony. But disharmony itself does not necessarily lead to bad things. Indeed, sir, scientifically, it is recognized that when you have teams, I believe, as usual, sir, I would have given it if I was preparing a speech, but it is accepted, and I will undertake to produce the document for the House, that the statement is that high-performing orchestras, and they've extrapolated this to businesses, dare I say, political parties and or law firms, when you have component team members who agitate and rub against each other, you get better results than when you have everyone singing from the same hymn sheet as such. So there may be some method to the madness where we allow diverging opinions and what some may deem to be friction and unnecessary sparks that results in a product that's better than one where everyone is saying yes, yes, yes. But I digress, Mr. President. I believe, sir, that there are certain elements of the legislation which do bear highlighting and concentration. I believe, sir, that Senator Watson has identified concerns which ought to be tabled and considered by the leader of government business and the leader who is responsible for moving the legislation through this House. Indeed, in the past, the government has given its assurances that certain points raised will be considered at a future time. We will wait and see if those assurances are given in this instance. For my part, sir, the following sections bear note. As I said, some of these points have already been raised by Senator Watson, but I believe that they also caught my eye and may have been lost in her delivery due to the resulting enthusiasm of the response to the same. So let me set out the section, sir. Section 3, which speaks to the Chief Labor Officer, recognizing that this does fall within the ambit of the Chief Labor Officer in terms of disputes The question is whether there will be the concurrent or the necessary increase in resources for this department. A cursory examination of the estimates that were just provided show that this department currently is at 1.9 million and is now moving to 1.95. Will this be necessary for the increased load that is anticipated to come from this legislation? Second section, sir, in relation to section 4, which deals with the removal of concessions. As highlighted previously by Senator Watson, the 7-day period for you as a business to receive notice that your concession will be removed is somewhat short, sir. 7 days is actually a very tight timeline, which is usually reserved for specific instances of legal appeals, in which circumstances, I believe, sir, the last time I saw a 7-day time period, it was in relation to taxation. Most instances, even with legal rights for an appeal, you have something like 14 or 28 days in which to make your application to say, I am not happy with what has been done. So that is something which I think is worthy of consideration to see whether this timeline is a bit sharp, especially given the importance of the removal of the concession and what may be a necessary impact of losing a concession. Imagine, sir, if you were a business who relied on the ability to get duty-free imports for your service, and you are told that you have been notified that your concession is no longer there and you have 7 days. Now, of course, that assumes that you receive the notice promptly. That assumes that it's delivered and gets to your attention promptly. And all of us, I think, are not naive to not recognize that when dealing with the vagaries of life, these things tend to have issues. So I think that is something that's worthy of consideration when it goes to the various committees for consideration. Section 6, sir, speaks to the issue of regulations and, of course, the much debated concern about the lack or delay of regulations being issued. Sir, we're supposed to have regulations for the Bankruptcy and Insolvency Act. They still have not come. I believe that was the early 2000s, 2008. We're still awaiting the regulations for the Employment Rights Tribunal, and I will come back to that, sir. Sir, we were here debating, well, it was in this place, but it was another location, where we were in Christchurch at the time, it was then royal decree or assent or stipulation, and there were regulations which were to be passed in relation to the COVID concessions that were granted for the minister and the regulations and the implementations for the tribunal to deal with those issues. That was discussed, that was an issue which came up, and the issue of the regulations to allow the legislation to have the impact that it is to have continues to be an issue which we need to look at. Now, sir, Section 3.4 calls for disputes to go to the Employment Rights Tribunal. In this regard, I have to echo Senator Watson and Senator Nichols, who both raised concerns with regard to the resources available to the Employment Rights Tribunal. Sir, the former chairman, who I would like to go on record to thank for his service, the retired Justice Christopher Blackman, who continues his service with regard to the Constitutional Commission. I'd like it to be on record. Set out in his departing correspondence issues related to the functioning of the Employment Rights Tribunal. The issues, sir, of a dedicated workspace. The issues, sir, of adequate resources of staff. The issues, sir, of the enactment of rules, subsidiary legislation, sir, regulations, and of course, the ability, although he did not raise it, so let me not put words in the honorable gentleman's mouth, to enforce costs and awards of the Employment Rights Tribunal continues to be a factor for consideration. So the issue of resources, and when again, sir, a cursory look at the documents that just by some form of providence, sir, these documents came today, that we look and we see in the Barbados estimates that the allocation for the Employment Rights Tribunal goes from 403,000 to 480 and 417,000. Is this allocation enough? And I will listen and wait for the government to respond to allow, firstly, are the issues which have been identified, I think, a few times over in relation to the Employment Rights Tribunal, will they be addressed? Will the Employment Rights Tribunal be given the ability to do its job as it's presently mandated, especially when considering the increased load that comes from this legislation? Sir, I believe, however, that it presents a lovely opportunity. We have a situation where both the government and the opposition are saying that they are champions of the workers. So I would like to throw down the gauntlet, Mr. President. I would like to throw down the gauntlet, sir, that between the government and the opposition, whoever adequately funds the Employment Rights Tribunal could make that claim with great authority. I thank you, Mr. President.
Thank you very much, Senator Kevin Boss. Other speakers? Her Honor, Senator Thompson.
Thank you very much, Mr. President. It has been for me an interesting debate. The question really is not whether, or really in addition to the question as to whether this is or is not a historical moment, what I find interesting about it is that it speaks loudly to the history of the political parties represented in this chamber. On the one hand, you have clumsy attempts to divert attention from what the government is attempting to do with this legislation by persons who are the inheritors of the party or the heirs of the party that came to this chamber and took away 8% of people's salaries, that came to this chamber and reduced severance payments from what they were to next kin to nothing, that came to this chamber and created policy and legislation which resulted in the dismissal of working class people all over this country, where every member of the household lost their jobs, when they were given no alternative work, and somebody has the gall to ask about ash workers, temporary workers, for whom alternative employment was found, people who were home, haven't been sent home by the Dems, and were made to work in a program given opportunities and income and dignity, and to be able to go in the supermarket and buy groceries like anybody else. Not people who are working for large sums for large entities, but ordinary working class Bajans who were put into the program to work with COVID, who were made to work as, given opportunities as school workers in a situation where a previous administration not only sent people home, not only sent home every member of the household, but provided no alternative training and no alternative opportunities in a situation when a Barbados Labour Party government is creating jobs, opportunity, income and employment, and then is also permitting people upward social mobility by paying for their university education when that was taken away by the previous administration. And on top of that, training for persons who may be displaced in various sectors is ongoing free of cost. that people can tool and retool and equip themselves for a vibrant and dynamic and rapidly evolving labor market. When I got galled, though, sir, that would be how it would be commented on outside of the sphere. I am merely quoting persons who are listening to them today, who would have suffered as a result of these policies. There are times, and I'm not suggesting to anybody what they should do, when perhaps rather than taking legalistic approaches or attempting to pull shadow things out of the air, you are best left in your seat, saying nothing and letting the moment pass, because then nobody can get up and remind the public that sitting in the chamber today are the new heirs of those who visited, as Bajans would say, sir, sufferation on the labor class in this country. On the contrary, sir, on the other side of the table, we have the inheritors of the union and the trade union movement and the policies of Grantley Herbert Adams. On the other side, sir, we have a party that has pioneered all of the major labor legislation in this country and all the benefits to workers. Make no mistake about it. And on the other side, we have the issue, the inheritors, and the pioneers of those who came in here, sir, and in the other place, and for the first time in this country, brought a minimum wage, sir. We have the same team who in this chamber in a previous year supported the provision of protections for those who work in construction and roadworks, gas station workers. You see, sir, for a long time, and now we will get a chance to talk some politics. For a long time, the Democratic Labour Party and its acolytes have paraded and held up their hands and said, we are the progenitors of integrity. We are the ones who are the fighters for the working class and labor in this country. But the facts and the evidence take you to the other side, that every time you look to see where workers and poor, small, black people in this country have been protected, it is the Barbados Labour Party that has done it. And people want to talk about their grandparents. I can talk to you about my mother, who with tears in her eyes talked about what it was like for her as a poor working class woman living in urban Barbados and working as a domestic from sunrise to way past sunset, unable to get home to her children, pregnant and tying her belly to conceal a pregnancy because she could not afford to lose the job, her feet swollen at night with your unreasonable hours, that as a domestic she worked in Strathclyde. And when Grantley Adams came and made domestics have to set working hours, and sugar workers have proper, different, improved conditions and working hours, her life changed. So if we want to talk about history, I'm not speaking out of it from an academic perspective. I do not come in here with the clumsiness of one who has to look at my history and turn away from it, because I know the history of my party is one of shame on this matter. I can speak from the perspective of having watched the tears fall down my mother's eyes when she talked about what life was like and what political interventions to protect the labor class meant to her. And this intervention here today, in the same way that we protected before maids and domestic workers, in the same way before that the Barbados Labour Party protected construction and road workers, in the same way before that we protected women and children and stopped them from working in mines and in quarries. Well, that's what the legislation says, it refers to mines, quarries, and in other areas, in the worst kind of conditions. That is what we are doing today. We are now moving to the hotel sector and making what is an ethical decision. Because in the same way that we said that when those who get contracts from government to do road works and related construction works benefit, that equally the workers must be treated with dignity and must have minimal conditions. And this legislation, the language of the legislation is very clear in that it is an act to establish minimum rates of pay and conditions of work for those who work in hotels or in the hotel sector and get concessions from government. During COVID, the government had to protect the hotel sector and give it monies to keep some hotels open and to keep some hotels afloat because some are indigenous hotels. There was no outcry from the Democratic Labour Party at that time. It was fine. But now that government is coming to legislate to protect the rights of poor workers, of the laboring class, not of capital, you are hearing all kinds of arguments about why it should not be and why it should not be done, and oh, it is not this, it is that, and so on. Capital takes advantage wherever it can, however it can, and of whomever it can. That is the nature of capital, and that is the nature of capitalism. And therefore, what this government is attempting to do is to say, look, you cannot be quarreling and saying that $8 a day is adequate for somebody to buy a meal in modern Barbados. Those are the kinds of things that this has given birth to this legislation. That we are seeking to say to the workers, we are standing with you and on your side to make sure that you are properly protected, particularly by those who are getting concessions from government. The taxpayers are supporting those concessions. Why then should not Barbadians benefit? But we are hearing all kinds of legalistic arguments and the issues are being obfuscated with ash rather than facing the reality of what is happening in here today. This is social justice being effective by way of legislative instrument. And let us look now at the pushback of capital, because capital always pushes back when you seek justice for labor. There is an allegation, as indeed there always is, that if we protect labor, people are going to get sent home. You know, I can go fire people because I can't afford this here. You're going to try to put me out of business, you know. I spare my people, you know. This is the kind of thing that you hear. But as usual, it is a straw man. When we establish minimum wages, you would have believed that the country was about to shut down. If Barbados put a minimum wage in place, the government went ahead with it, and what has happened? People have been protected. People are able to get more income. Unemployment has gone down rather than going up. Equally today, we are saying that we are now moving to protect a certain class within the hotel sector. Capital, then, their next strategy is to try to create fear. To try to create fear. To tell the workers, well, you know, y'all really putting our backs against the wall. Because labor must never get through. Labor must never progress. Capital must always be the winner, and profit margins must always rise. And that is the thinking which is driving the opposition in every way to this piece of legislation. Another criticism of what the government has been attempting to do is, well, if the problem is not widespread, well, what is the need for the legislation? Well, there can't be any need for the legislation if there are only a few incidents of it in the marketplace. But it is the role of government to protect on one hand and to prevent on the other. So government cannot wait until there are entrenched widespread abuses. When the horse has bolted from the stable to then play, we come in with, help me shut in this door here. You have to come beforehand. When you see negative trends that are abuses of your workers developing in the marketplace, you have to take action early. You have to prevent, you have to protect. And that is what government is attempting to do. So it is not a matter of whether there are widespread abuses. There are cases of abuse. Senator Nichols spoke eloquently to what he could speak of from personal knowledge. And government now is moving to say, if you want our concessions, our workers, our Barbadian workers must be treated properly. We have to stop bad practices from taking root. It has also been said that there are few complaints. So deal with the few people and do not legislate. Legislation attempts to establish national standards for all to follow, so that the few complaints do not grow into many complaints. Because the reality is that once a business sees that another business can get through with an act of abuse or exploitation, immediately they look to replicate and to perfect the mechanisms of abuse and exploitation. And this government, therefore, is taking a shot across the bow for those who have not yet started and say, haul and pull up, or cease and settle, as one would put here elsewhere, sir. So the government is taking measures to intervene in a sector where there are complaints of abuse and wrongdoing, to address those and to stop the problem from growing at any rapid rate. This is a significant act or action being taken today. But what is important about it, sir, is that when you place it in the historical context of politics in Barbados and policy of political parties in Barbados, you will see that it walks firmly in the trajectory of Barbados Labour Party politics, protecting the workers and the working class, and on the side of labor in this country. And you will see that, as usual, the Democratic Labour Party is seeking to use arguments that really do not protect or support the worker in this as is the case in this instance. And we have to be deeply concerned about people prancing up on fake reputations as protectors of the working class. Look to the reality of the policies of the legislation and of the actions taken by the administrations over historical periods. Go back. And if, sir, you were to go through, I spent some time this afternoon going through legislation historically to identify the record of the Barbados Labour Party going back to the time of Grant Lee Adams, and then following through into the period of Tom Adams, and coming into the days of Owen Arthur, and now under the Mayor Mottley administration. The consistency of the support for labor in this country and the working class, the Barbados Labour Party has never failed, never wavered, never prevaricated. This is yet another measure that we are doing to support ordinary people in this country, as we have consistently done. And those of us, and I think I speak for all of us in here, who really came from solid working class roots, want to be able to protect workers, to promote upward social mobility for them and their families, and to set national standards of the highest level, making it clear that when it comes to drawing a line in the sand, we are not going to stand on the side of capital against labor. We are not going to do it. Where labor, we understand and recognize and concede and support the role that labor has in creating jobs, in helping to build the economy, but it cannot be on the backs of or at the expense of the ordinary Barbadian. And those who are seeking to make arguments for why this legislation will not work, cannot work, is unnecessary, should not be brought, and kadir, look at these poor businessmen. Might as well stop. Because we are confident that is, as in other measures that we have taken, which have protected the laboring class in this country, historically and more recently, that this measure will work, that it will have the impact that we intend, and that ultimately those people who work in the sector being targeted will be the better for this intervention having been taken. In those circumstances, sir, it is my absolute pleasure to support the measure before the House and commend it to the workers of Barbados. Those in the hotel sector know the long list of complaints and how long they have been asking to have them remedied and rectified and resolved. And by legislative amendment today, the Barbados Labour Party, sir, answers the cries of the workers in the hotel sector. And I am happy to stand with them solidly, resolutely, and unapologetically. I'm much obliged to you, sir.
Thank you very much, Your Honor, Senator Thompson. If there are no more speakers, I'll ask Senator Blackman to close.
Thank you very much, Mr. President. Mr. President, sir, I've sat here and listened quite attentively over the past few hours. Yes, I certainly did enjoy it. Over the last few hours to what I consider not only a historic debate, as I said at the onset, but as others have demonstrated, a very timely and very passionate debate for a number of reasons. But some of those reasons clearly are not of the same origin. And I really want to start it might wrap up on that basis. Because today, for me, will forever be etched in my memory, and I'm sure many Barbadians who are watching and listening as well, will be forever a time in the history of Barbados' politics where one party, the party of Grantley Adams, a party with a history at its core on representing the interests of labor and workers. And on the other hand, a party once a shadow of itself, now trying to be reincarnated as a shadow party, bearing no resemblance to not only reality, but to the plight of people who we all come from. Lest we forget our history, and I really want to thank Senator Morris for capturing so well the essence of who we are and why this bill is important not only for today, but also to correct a number of historical wrongs, as it were, in moving the interests of our people and workers forward. Senator Nichols, I pay kudos to you for also settling a number of the legal queries and questions surrounding this debate in clear and fine form and fashion, setting out for us what are the parameters of the bill and what are the areas that are not in the bill, as was alluded to by others. And we hear the question of due process. It came up time and time again. And you know, it is very easy for persons to plead the whole matter of due process. And Mr. President, sir, I would have thought that today would be a seminal moment for both Senators Watson and Senators Walters to have used the first occasion in terms of a debate on the first day of the debate, or them debating, since they were voted out as a party from Parliament in 2018, to have come in on their first set of debates on the first day, and to firstly, even before supporting the bill, to have, on behalf of the Democratic Labour Party, apologize for all of the atrocities meted out to them and to the population between 2008 and 2018, when, as the Deputy Speaker, in clear terms, reminded us that not only were workers sent home, they were left with an empty bag with no recourse of training and support. But instead, we got up in here and we heard soundbite after soundbite, things to capture the evening news, with no agenda to advance the working class people of this country. And I say to the honorable member, you're now left alone. She's now left you here alone, which is fine. And I understand. But I want to send the message that if you're going to come to public life to represent people, you must never forget where you come from. Never. And whilst I'm disappointed in the two honorable senators from the Democratic Labour Party on this bill, I am not surprised, because an apple does not fall far from the tree. And we are living sometimes, Mr. President, in the era and the times of betrayal.
Senator Blackman, there's no betrayal in this honorable the Senate. You're not making any reference to anyone here, I take it. Oh, okay. Please press on there.
Mr. President, I agree. I'm not doing that at all. I'm simply talking about in the broader context of betrayal and in the moment of when persons find it convenient to forget who we are, where we've come from, and the task ahead. That is the context in which I speak. But I go on, Mr. President, because I also would have thought that the occasion today would have presented members on the other side, not only to support the bill, because it's a bill to support, but as I said at the onset, where do we stand relative to the rights of workers? As Senator Nichols captured it so well, if you are the beneficiary of a concession, in whatever form, what the bill is saying to you is that you simply have to ensure that you adhere to the practices that make sure that workers have their rights guaranteed. Senators on the other side alluded to the fact that it is warm over soup. I could not believe that I heard that in here today, because he also mentioned the fact that members of the union came in the other place last week when it was being debated, as if them coming to do what any ordinary Barbadian would do when your rights are being advanced. You're there. You're there to hear the debates and to see what will impact me, how it's being advanced. But as I said, what we witnessed today bears no resemblance on reality of ordinary workers. But I want to treat to a few issues as well. We heard a number of things relative to the dispute mechanism and the process. And I want to give the assurance to honorable members and to those listening that if there is a dispute, and I encourage, Mr. President, when I was growing up, and I'm sure honorable members have had the same thing, your parents always say, you know what, you need to read. Read. Nowadays, people don't like to read. Take some time to read. And I will not get up in here and, quote law and everything. I have a law degree. I have a master's in law. So here is not to coming in here and, like if we're on a legal debate team. This is about the lives of people, Mr. President. And therefore, when you read the bill, it is evident and clear to everyone, whether you're a learned friend or not, that there are mechanisms of due process inherent in the bill. They are there, but I encourage persons to read it. And as Senator Nichols did so well, he also brought us to where we can find them. On the matter of consultation, the bill is very clear that any decision to take away a concession will be done by way of consultation. So a minister is not going to get up and say, you know what, concession gone for you tomorrow. No, there is a process, there's dialogue. Even the minimum standards that we're talking about, it is going to come about by way of consultation. But to give an impression that the bill is going to take away the rights of entities without due process is a bit, and I don't want to say a bit, it is disingenuous and regretful. But that being said, Mr. President, sir, on the issue of the employer and the notification, the employer must be told why before any action is taken, and that's what I'm saying, the consultation process is very clear. Now, on the issue of the Barbados Revenue Appeals Tribunal, it is being used because the issue is both a revenue issue and a tax matter. So therefore, that entity is best housed and placed to treat to these issues. And I also want to make it clear, again, no sector will be affected, and it comes back to the point of consultation, Mr. President. No sector will be affected until the rates and conditions are set out. And set out how, again? By consultation. I want that word to stick in my colleagues' heads today. Consultation, consultation, consultation. Very important. Nothing in this bill, there's no sneaky hand on the handy thing here. It is open, transparent, and consultative. And therefore, every party involved, particularly in circumstances where they may lose a concession, consultation is there for them as a recourse. Now, when we look perspective of where we are. We've heard the debates on why the bill should be supported. We've heard other debates on, well, I sort of support or I support but this and but that. I want to cast the Honorable Chamber's mind to 1982, Mr. President, sir. And let's look at the convention. The original convention as set out by the ILO in the 1940s. There's only one country that has associated itself, and I will repeat, and Senator Walters, I'm not sure if you are aware of this, but I'll say it for your interest and for those in the Democratic Labour Party. The only party, the only entity or government rather, and the only political era that has gone as far as even to denounce the convention itself after ratification was under the Margaret Thatcher administration. Now, you now have a circumstance in 2024 where some honorable members find themselves in the same company. I said today is a historic day, but never did I imagine that some of them would be in that sort of company. But let the record reflect the position of the Democratic Labour Party on these issues. But on the Barbados Labour Party side, we are absolutely clear as the Labour Party, and I repeat, Mr. President, as the Labour Party, we stand with workers. And this notion that it is workers or employers, that must move from our discussion in Barbados. It is not one or the other. Of course, you can't have a company without workers. Workers need an employer. But you cannot have companies that are advancing their interests at the expense of workers. And therefore, as we bring this debate to a close, and as we go our separate ways long after this debate, the question must always be, not only where did we stand today on this debate, but where will we as a country, and what ethical compass will we ensure that as new challenges emerge in the labor market 20, 30, 40 years from now, long after some of us may be gone, where will we stand on issues of labor? And as the Honourable Member Thompson rightly said, when you look at the history from Grantley Adams, Tom Adams, Bernard St. John, Owen Arthur, and now in the era of Mia Motley, the Labour Party's record on labour and advancing the cause of ordinary Barbadians is undisputed and absolutely clear. And it is to that end I'm very proud to once again support this bill. And I could only hope and pray that those who have erred on the side of history would reflect on their ways and correct that wrong at some point in time in the future. But I'm obliged to you, and I want to commend this bill and read it a second time. I beg to move that this bill be read a second time.
The question is that this bill be read a second time. Will all honorable senators in favor please say aye. Those against please say no. I think the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of the bill.
The question is that I do not leave the chair and the Honorable the Senate resolve itself into committee for further consideration of this bill. Will all honorable senators in favor please say aye. Aye. Those against please say no. I think the ayes have it.
The Senate is now in committee.
Clause 1.
Madam Deputy President, I beg to move that Clause 1 stand part.
The question is that Clause 1 do now stand part. Will all honorable senators in favor please say aye? Those against, would you say no? The ayes have it.
Clause 2.
Madam Deputy Speaker, I beg to move that clauses 2 stand part.
The question is that Clause 2 do now stand part. Will all honorable senators in favor please say aye? Those against, please say nay. The ayes have it.
Clause 3.
Madam Deputy President, I beg to move that Clause 3 stand part.
The question is that Clause 3 do now stand part. Will all honorable senators in favor please say aye? Those against, would you say no, please? The ayes have it.
Clause 4.
Chairman, or Chair, Madam Chair, I beg to move that Clause 4 stand part.
The question is that Clause 4 stand part. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Clause 5.
Madam Chair, I beg to move that Clause 5 stand part.
Question is that Clause 5 do now stand part. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Clause 6.
Madam Chair, I beg to move that Clause 6 will stand part.
Question is that Clause 6 stand part. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Clause 7.
Madam Chair, I beg to move that Clause 7 stand part.
The question is that Clause 7 do now stand part. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Clause 8.
Madam Chair, I beg to move that Clause 8 stand part.
The question is that Clause 8 do now stand part. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
First schedule.
Madam Chair, I beg to move that the schedule be the schedule to the bill. First schedule to the bill.
The question is that the first schedule be now the schedule to the bill. The first schedule be now the first schedule to the bill. All honorable senators in favor, please say aye. Those against, please say no. The ayes have it.
Second schedule.
Madam Chair, I beg to move that the second schedule be the schedule to the bill.
The question is that the second schedule now be the second schedule. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Third schedule.
Madam Chair, I beg that the third schedule be the third schedule to the bill.
Question is that the third schedule be now the third schedule. All honorable senators in favor, please say aye. All those against, please say no. The ayes have it.
Fourth schedule.
Madam Chair, I beg that the fourth schedule to the fourth schedule, added to the bill. Be the fourth schedule added to the bill.
Question is that the fourth schedule be now the fourth schedule to the bill. All honorable senators in favor, please say aye. All honorable senators against, please say no. The ayes have it.
Report.
Madam Chair, I beg to move that you now report to His Honor the President the passing of one bill in committee.
The question is that I now report to His Honor the President the passing of one bill in committee. Will all honorable senators in favor please say aye? Aye. Those against, please say no. The ayes have it.
The chairman has reported the passing of one bill in committee.
Mr. President, I beg to move that this bill be read a third time.
The question is that this bill be read a third time. Will all honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill now pass and be cited as the Labor Clauses Concessions Act 2024.
The question is that this bill do not pass and be cited as the Labor Clauses Concessions Act 2024. Will all honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 3, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Law Reform and Law Revision Amendment Bill 2024.
Senator Cummins.
Thank you very much, Mr. President. The amendment before the Senate is certainly nothing as monumental as that which we have just finished debating, but it was my absolute privilege to have sat through what was perhaps one of the most comprehensive presentations on social justice, labor rights, and the history of politics in Barbados that we have had in the Senate for some time. I think it augurs well for what is up ahead and what is still to come. But, Mr. President, the bill before us seeks to regularize the functionings of the Law Reform and Law Revision Commission that was established in 2019 under this Barbados Labour Party administration, Mr. President. This amendment, as you can see, order number 3, Mr. President, seeks to, in effect, create the provisions that will allow, through these amendments, for the establishment of the Law Reform Commission to function as effectively a body corporate. Now, Mr. President, it is an interesting thing when you sit within the bowels of government and you watch the way in which the system works, and you watch the way in which approvals are undertaken, the system for the procurement of services, and how those things then impact on the delivery of services, Mr. President. And so the Law Reform Commission has found itself since 2019 in a position where it has been functioning within the umbrella or under the umbrella of the Office of the Attorney General. And the Office of the Attorney General has provided both space as well as legal cover for the work of the Law Reform Commission. But as a department within a government, every body of work, every paperclip, every consultant, every administrative role that needs to be procured has to go through the very cumbersome supporting mechanisms of central government. They cannot, Mr. President, as is the case in many of our entities that are established as body corporates, they cannot hire for legal researchers. They cannot hire, Mr. President, to be able to bring in Crown counsels, to be able to bring in supporting work. They have to depend on the Office of the Attorney General. And so If I were to refer to the legislation that is before us for amendment, Mr. President, the legislation quite simply makes changes in 7 ways, and it has outlined them in your documents. The short title is there, Mr. President, but it speaks, Mr. President, to the inclusion of one language that reads as follows. Establishment of a Law Reform Commission. There shall be a Law Reform Commission. The Law Reform Commission is a body corporate to which Section 21 of the Interpretation Act applies, and if you were to go to Section 21 of the Interpretation Act, it outlines what is attributed to a body corporate and what kinds of responsibilities and liabilities are accrued to that entity. As we go on, Mr. President, it talks about the purpose of the Law Reform Commission, and I want to spend a few moments there, Mr. President. I want to recognize that in 2019, we had a number of illustrious, well-esteemed and respected legal professionals appointed to the role of law commissioners. They include persons who have served at the highest level in the judicial system in this country and who have interacted both as those who are users of the system, as well as those who are arbiters of the system, and together they constitute the Law Reform Commission. Since 2019, Mr. President, they started out to look at what the reform agenda, as is proposed in the amendment at Section 30 in our documents. The reform measures in 2019 that they identified included the Companies Act, CAP 308. I happen to be the minister with responsibility for administering the Companies Act. The Companies Act is an old, very dated piece of legislation that has been tinkered with administration after administration, year after year, to the extent where, in some instances, it is not even recognizable. This Barbados Labour Party administration, this government, has therefore undertaken the responsibility of doing a complete reform and updating of, one, the company's policy, and therefore the Companies Act and resulting legislation that will drive it, to ensure that Barbados has a fit-for-purpose 2024, 2025, 2030, 2035 piece of legislation that it did not have when this original legislation was crafted. It is an absolute necessity, Mr. President, and that has been one of the areas of reform which is underway under the umbrella of the Law Reform Commission. It also includes, Mr. President, the Property Act, Family Law Act, Status of Children Reform Act, a piece of legislation that comes also from within the bowels of the Barbados Labour Party under Tom Adams himself, the Tenantries Freehold Act, updating those pieces of legislation and making them fit for modern purpose. The Court Process Act and the Community Legal Services Act, those were the initial bodies of work that they in 2019 agreed to work on. But if I were to come back to the challenges that I have just cited and the issues that an entity functioning under the Office of the Attorney General has been encountering, it would be to say, Mr. President, quite simply, that they have not been able to deliver on the mandate that was intended and the work that was set out and the reforms that they were assigned and they took responsibility for, because they simply have not had the resources available to them to be able to deliver. Mr. President, in 2019, they did not at the time even have a dedicated office. They now have an office assigned to them, and they have described it in glowing terms, and it is fitting for the work of the persons on this committee in the new complex, the Sir Henry Ford and Sir David Simmons complex down on White Park Road. They now have spanking new accommodation to accommodate their work, and what this amendment seeks to do, quite simply, is one, to allow for the commission to function by way of appointments, having the functions, a director, hire staff, be able to bring in experts, have the execution of a law reform program, Mr. President, in 2021, immediately post-COVID, because COVID resulted in obviously a slowing down in the way in which many institutions of government and all across the country and all across the world worked. We could not imagine, and I was somewhere, I don't even remember where, Mr. President, I was somewhere, and I said, I made a flippant comment, and as I said it, I realized what I'd said, and I said, back in 2020 when the world came to a stop, and I thought to myself, and I immediately captured that, and I said, but Did we ever in this room think that there would be a time where a statement like that, where the world came to a complete stop? Would we ever be in a moment where we would say a thing like that? And it is true. We lived through the moment where except for 2 years at a minimum, the world really did come to a stop. And so the Law Reform Commission and its work became thwarted during that period, but they continued to work. Now, what are they proposing to do? We have heard, certainly from the senators who left us, who were here before, on more than one occasion, and others who are still with us, about the need for us to have a legislative agenda, to have a legislative calendar, to have an indication as to what bills are coming to Parliament and in what sequence and what is on the government's agenda. I can give you the assurance that the government of Barbados has, certainly at the level of the government, a legislative calendar where every ministry is responsible for shepherding pieces of legislation through the system. But they become bottleneck simply because the Office of the Chief Parliamentary Counsel, where the legislative drafters sit, is simply understaffed, and it has been understaffed for a long time. But not because for want of trying, but simply because, Mr. President, it has been almost an impossibility to find legislative drafters to hire in this country. And the reality of it is that the Honorable Attorney General in the other place has spoken about it. He's talked about the fact that this is a challenge that has been in existence all across the Caribbean region. In fact, even beyond the Caribbean region, he made mention to the fact that the Commonwealth, to whom we reached out, said that this is a problem across the broader Commonwealth region as well, not just in the region. And so you will see in the report, Mr. President, if you were to take the opportunity to go through it, the Law Reform Commission between 2019 and 2022, that Impact Justice, funded at the time by the Government of Canada to support the region in legislative drafting, would have developed a cadre of professionals who were lawyers in their own right and then were being financed to pursue the LLM degree in legislative drafting, to be able to have persons available to the region to do this work. But the question must be asked, how many of those persons who completed the LLM in legislative drafting at the University of the West Indies are in legislative drafting now and who have gone back into their previous professions? The reality of it, Mr. President, is that very few of them have continued in legislative drafting. And so what the Office of the Attorney General has sought to do is to find those persons from wherever they are within the international community where they have the capability to absorb and to function within a Commonwealth law jurisdiction, that those persons are now on retainer to support the Office of the Attorney General and specifically the Office of the Chief Parliamentary Counsel. But the work of the Law Reform Commission is also that which is supposed to focus on those things. And so the expectation is that experts will be hired by the Office of the Law Reform Commission to be able to take on responsibility for reforming the laws and also drafting and making recommendations. Mr. President, I want to take the opportunity as well to recognize the contribution of entities like Impact Justice, the Commonwealth Secretariat, all of whom have shared draft model bills on a range of things. And they include some of the current things that we have seen passing through this honorable chamber, including items which, for example, are before committees in both houses of parliament, including model legislation that has been supported. And so what we are hoping to be able to do with this legislation is to ensure that by establishing it first as a body corporate and attributing to it all the rights and obligations that are assigned to a body corporate, that this entity would be created in the first instance, Mr. President, that it would have the ability to hire staff, to be able to execute on the procurement of goods and services, to be able to continue its work, to examine model laws, and to be able to support the work of the government and the country more broadly. And I say the country more broadly, Mr. President, in summary at this point, because I'm not going to go into a significant detail on this matter. But I want to say, Mr. President, that aside from the government's agenda, in an earlier discussion, I heard the comment being made about consultation. This is a government that has, even before we had a new opposition, we consulted, we consulted, we consulted. We engaged and we opened the door at all times for people to come forward and give recommendations. The Law Reform Commission was no different. The Law Reform Commission, Mr. President, received all kinds of submissions ranging from the Barbados Association of Medical Practitioners, CITUSAB, private individuals who came forward and made recommendations on legislation that they felt needed to be reformed. They are all captured in the reports of the Law Reform Commission and the recommendations that they have made to be able to execute on those recommendations. And so we are simply here today, very simply put, Mr. President, to be able to empower this agency to deliver on the lofty mandate that it has been assigned. And it is my expectation that this is a matter that therefore should attract very little contention, but in fairness, perhaps I may be too hopeful, given the fact that a matter which really ought not to have attracted too much angst actually did. But I want to commend this bill very simply to this honorable chamber. I want to commend the work of the Law Reform Commission. I want to commend the work of the Law Reform Commissioners who have continued to deliver even under very difficult circumstances. And I want to stress that from the government's perspective, the work of the Law Reform Commission remains critical to the development of a modern set of laws that Barbados can be proud of. We don't yet have that. We in this honorable chamber complain oftentimes, or hear others complain all the time, that you have difficulty finding principled legislation or consolidated legislation because they're not all in a single place. The work of the Law Reform Commission is meant to address many of those things. We often have difficulties, Mr. President, with finding where the legislation interacts with the amendments that are before us. The work of the Law Reform Commission is expected to address those things. And so we would imagine that all members of this honorable chamber will therefore be in support of the establishment as a body corporate of the Law Reform Commission, allowing it and its very able leadership of the Law Reform Commissions to pursue the administrative acts that are necessary to allow it to execute on its duties. And with these very few words, Mr. President, I beg to move that this bill now be read a second time.
Thank you, Senator Cummings. Senator Watson.
Mr. President, excuse me, I am somewhat of an oddity in my profession because I like legislative drafting. They probably would say those who can't draft. I differ because laws, of course, are the embodiment of government policy. For me, they are your marching orders, your directions, set out how things are to be done. Thus, I must take this opportunity to differ with a sentiment expressed in an earlier debate here today that addressing the details of the bill being then considered was an academic exercise. It cannot be considered to be an academic exercise because it is a working document.
On a point of order, Mr. President.
What's the point of order?
The point of order that is that the honorable member, by seeking to bring into this debate points made in an earlier debate, would be in breach of the rules of the standing orders. I will give the honorable senator adequate time to learn them, but this is a lesson, sir.
The honorable senator should also instruct her colleagues on the government side, given that just a few moments ago, a similar reference was made to an earlier debate. But I will move on. I will not be distracted by meaningless interruptions. No.
And let me just say, I've taken note of the points. I allowed both senators to have a glancing blow. I didn't think it went far enough to represent a reflection or comment on previously passed legislation, but rest assured, I listened very carefully and monitored. But all senators take note that a substantive motion is required in order to reflect on previously made decisions. But however, from time to time, whether recent be same sitting or early in the session, there will be references made to legislation passed, but certainly not a full reflection or revisitation of the issues and content therein. But certainly the note of the standing orders is important for all to consider. Please continue, Senator Watson.
Thank you, Mr. President. Mr. President, the Law Revision and Law Reform Amendment Act 2024 is of interest to me as a practitioner. And I will just make a few comments on my observations as to where I think some enhancement might be required. I am not against the bill, but I do think that there are some additional amendments that perhaps ought to be made or can be considered for future drafting, ironically. When we look at section 29 of the recommended section 29 of the bill, so that's section 3 of the bill, funding for this new body corporate is going to be key. And experiences in other jurisdictions are that have had longstanding law reform agencies point to control or frustration of the agency's work through the control of the agency's budget. So I want to exhort the government to ensure that the Law Reform Commission is adequately resourced, adequately having the appropriate funding, so that its very important work can be executed, and so as to avoid making their work merely performative. When we turn to the appointment of members of the Law Reform Commission, we acknowledge that the intention is to continue to have the commission comprise merely senior attorneys, including a judge. I differ. And at this point, I do want to acknowledge the work of the current commissioners, and we in the Bar Association see their work from time to time and are requested to make comment. And I want to thank you, because drafting is a somewhat thankless task. And so I want to formally acknowledge their work and thank them for that work. We know, Mr. President, that lawyers are the font of all knowledge. Everybody can laugh now, except the lawyers. Of course, acknowledging that, we do also accept that modern law reform systems will require the inputs of other knowledgeable experts. And in fact, we also have to acknowledge that the presence on a law reform commission doesn't necessarily mean that you are expert. Therefore, I would ask the government to consider adding some diversity, socio-economic diversity, cultural diversity, when we look at the membership of the Law Reform Commission. I do not believe that it has to be only lawyers on that commission. The approach that I am recommending has been taken in some jurisdictions, which we tend to look at. When we look at model legislation, Canada, New Zealand, they have included other disciplines in their law reform commissions. And I think that no one could reasonably oppose that recommendation. It is an approach that I think Barbados ought to take. Indeed, that seems to me to be the approach that we have taken both with the Constitutional Reform Commission and the Parliamentary Reform Commission, and I think that that's what we should do with the Law Reform Commission. And in fact, this bill itself, when it refers to advisory committees, I think that specialized committees at 34C actually contemplates that you might need the inputs of other people who practice other disciplines, and I think that that can be embedded in the composition of the Law Reform Commission itself. I would also point to the publication of the plan for the Law Reform Commission. So there's a requirement that a plan is provided to the Attorney General no later than the 31st of January annually. And in its report, the Law Reform Commission has said that they actually provided a report for a longer horizon. And that is useful for many reasons, planning purposes, for us to understand, as the Honorable Senator Cummins said, for us to understand what the government's legislative agenda will be. What I would say is that rather than just end at provide it to the Attorney General, that it should be published, similar to publishing the reports or laying the reports in public in Parliament, which means that the rest of us will have access to those reports. My final issue that I wish to address, not an issue, but I think it is an absence in our legal environment, an absence from this bill, and it is something that Senator Cummins actually raised, and that is access to legislation in Barbados. Now, Mr. President, when I used to work in a company as in-house counsel, and when I came out and decided to open my office, I looked everywhere for consolidated statutes. And perhaps it was my good luck that I couldn't find them, and I was sent from department to department to department, all of the logical departments. Maybe it's a good thing that I couldn't find them, because they were priced at about $10,000, and that is quite some time ago. However, I find myself, in my family, we make up words. I find myself trepidated. That's a made-up word. Anybody can use it. I license you to use it. I'm hoping that I can, one of my bucket list items is to find a word that I have invented on the Oxford New Word List, or word for the year. So I hope that one of these days I will see that. But I'm trepidated when I have to find legislation in Barbados, particularly when I have to search on the printery website online, because it is difficult to navigate. I acknowledge the effort to make laws available online, but it has not been executed in a way that makes it easy for anyone, quite frankly, to navigate. And Barbadians ought to have access to their laws. I view it as Barbadians' laws. And what we find is that we can go to the Supreme Court Library, or we can go to the law library at the University of the West Indies. I say we, lawyers, I don't go, I send my junior, but most people can't access those laws, the laws in that way. And I think Barbadians are entitled. And while Senator Cummins did make reference to an intention to have the laws located in an area where they are readily accessible, that is not one of the functions that is stated. And I recommend that it is stated as a function for this reason. That is actually not an add-on, a simple task. That's a very important, specific task that would have to be performed by the Law Reform Commission. They would have to have adequate staffing, and if we're looking at hard copies of legislation, which some people might want to have access to, they will have to have the physical space, or perhaps provide equipment so that people can come in and navigate soft copies of the legislation. That goes to funding. So I think that specifically that ought to be listed in the functions of the commission. It is important to have that access for those of us who are working with the laws, but then for anyone who has a curiosity, who has an issue that they're dealing with, where they want to be able to research the laws. And that is a recommendation that I exhort the government to take into account. I have listened, certainly in the profession, and over the last couple of attendances to this chamber, we have had members express concern about not being able to access the legislation. And so I think that that's most certainly something that the government ought to pay some attention to, look at and fix it here, or fix it as soon as possible hereafter. Mr. President, for me, the rest of the bill merely sets out business-related issues for the Commission, and I think that it is appropriate and it is timely, and I most certainly support any effort of the government. Everybody might seem a little bit surprised, but I support the effort of the government to ensure that this work is adequately provided for and supported, because, well, they're the laws, and they're important for our functioning as an economy, as a society. Mr. President, I thank you.
Thank you very much, Senator Watson. Senator Nichols.
Mr. President, I don't propose to delay the chamber in a contribution to this debate, but I do think it is important that a number of points need to be made for the benefit of the public who's listening and also for the record. Mr. President, this legislation came into being about 5 years ago. Law reform and law revision, two fundamentally different aspects of the law that are important. I think Senator Watson touched on it a little bit. Sir, it is difficult to find, from a conceptual level, to justify what is Barbadian law. And I think that even although we've had a constitution for almost 60 years, we've had University of the West Indies law faculty, we've had judges coming out ruling on Barbadian law, we've had our own parliament passing laws. A lot of the laws that we have passed into effect have come from places, societies, and cultures that are fundamentally different from our own. And you get the impression that it is almost like when you are wearing a ill-fitting garment from a other relative or a shoe that is too small, too big. We have to take ownership and pride in them, but at the same time, we recognize that they are not fundamentally our own. And I say that, and I see the look of consternation on some of the other senators, but the laws that we inherit or that we bring into our own domestic sphere, coming right down the stream, were never meant to govern the societies like ours in the Caribbean. And we have struggled often, even when we have carved out legislation specifically for the Caribbean and specifically for Barbados' needs. When we look at some of the judgments of the courts have this unyielding fidelity to the English common law as this indivisible system of law. And even although our Constitution is in writing, and it is what we would say sui generis in a class of its own, we have had many instances where the constitutional provisions that are spelled out in our Caribbean countries, where there's no written constitution in England, has been interpreted as if it mirrored the common law of England. We spoke earlier today of collective bargaining and the right to freedom of association, but one of the earliest cases in the Caribbean, Mr. President, is Cullimore versus the Attorney General, in which the courts in the Caribbean said the common law does not know anything about collective bargaining, so therefore the right to freedom of association does not include it. And we have had a systematic attempt, Mr. President, to fashion and refashion our laws within that frame, so that this debate is timely. The reorganization of that voluntary group of lawyers in the Attorney General's office that moved from a voluntary group into a department, now into this autonomous body corporate that is contemplated here by the passage of this amendment, is monumental, because it gives us the opportunity, Mr. President, to create a systematic basis for the reformers of our laws. And when we speak of reform, Mr. President, there are so many things going on in the field of law today that the mind boggles as to how these officers or these employees will be able to deal with all of the work. Mr. President, if we were to tell you that the basis on which people organize businesses is in the form of a contract, whether in writing or evidence in documents or orally or what's not, that is the way business has been done for hundreds and hundreds of years. But we are now in the era of disruptive technologies that require a different legal framework to manage these things. There's something called a smart contract done on the blockchain, that the parties, all of the relevant terms and conditions of their business is organized on a blockchain platform. And if there's a breach, you don't need a court. The algorithm resolves the matter for the parties. We need to have laws to govern the interface between smart contracts and how we do business in the future. Because artificial intelligence and disruptive technologies are things that are now important, challenging the way in which law has been conceived. Hundreds of centuries of common law principles are being challenged. This is the thing that big societies with a progressive view for the future are contemplating as we speak. Mr. President, the University of West Indies is conducting the commercial workshop, commercial law workshop in July on this very issue. Why do I say that, Mr. President? To what extent do we as a society have people capable of being able to be the leaders in these respective fields to which Senator Watson spoke? So that the reform of all law has to take on a much more robust, systematic approach to it. And I would really like to call, Mr. President, for some training to be done for the benefit of lawyers to engage in not only the process of drafting, but in the process of engaging in law reform. Mr. President, this bill also speaks to the question of law revision. And these are some of the comments that Senator Watson in her last part of her speech was referring to. Yes, it is difficult to deal with legislation because we have not had a commitment to revising the laws of our country when they have been passed in this place. In fact, my experience since returning to the chamber almost now 2 years is that there have been bills that have been brought here for the first time and have come back for amendment. And there has been another amendment, a third amendment. And you now have to try to work out how you're going to deal with the bill to amend the act, which does not reproduce the previous legislation, but it says clause 2 substitutes section 29 by deleting this paragraph, and it becomes even difficult for persons to participate in debates of this nature because we have never had, or we have not had for a long time, a consistent commitment to the revision of our laws. It is difficult, Mr. President, to find in one place the Constitution of Barbados, and we have not had many amendments to our Constitution to the extent that why is it impossible, or I should say impossible, Mr. President, why is it difficult for somebody to produce a Constitution with all the necessary amendments and not give me the 1966 Constitution and 6 amendment acts that have been passed, so they have to sift through them in order to determine what is what. That is why people make some comments that they make, not understanding that the Constitution has been substantially revised within the context of our own Republican Constitution, and understanding where that goes. So, Mr. President, I'm calling for a more robust approach, not only to, I'm trying to find work for lawyers, but so that the work of the Law Reform Commission can be able to engage the services of experts or persons who are able to inform of a lot of the things that are necessary. Sir, I am worried that we are only at the tip of the iceberg here. This is necessary. These reforms are necessary because I do not have this unyielding fidelity to the structure of our civil service and the way how the civil service conceptualizes employment and work for people. That is too cumbersome for my mind. Perhaps that was a time before, but certainly hiring civil service on the way in which they are done and not knocking that process is not going to allow us to have that flexibility and nimbleness that is required in order to meet the legislative requirements of reforming Barbados's law to keep our law current. Mr. President, we have too many laws on our statute books that have long passed their time. We have laws that have been conceptualized in the Victorian period or the pre-Victorian period that are still laws in our country. We have approaches to these laws that have been consistent over the last 60, 70 years that is not synchronizing with the way in which the society has evolved in terms of understanding the mores and the various values that the society exudes. But they're the law. And it reminds me of that discussion in Lewis Carroll's book, and also Shakespeare's book, when the law would have to be enacted. When that discussion is between the characters in one of Shakespeare's plays, it escapes me now, Mr. President. And also Dickens in Oliver Twist speaks about it, where the characters bumble and so. How can the law say these things? We confront these every day. We don't change it because this is how the law has always been. Mr. President, do you know that if you wanted to sell any meat anywhere outside the precincts of this building, there's an 1846 piece of legislation that would say that you can't sell meat or cold storage? And that law that was contemplated to restrict commerce among people in a society that evolved just out of emancipation is the law that the police used to run vendors off the street for selling clothing, when the law itself does not relate to clothing. When the law only speaks of two markets, Fairchild Street, there's no Fairchild Street market anymore. But we still have a Market and Slaughterhouses Act on our statute books because we have not given to reform of law the energy that is needed. Yes, in the 70s, we welcomed the outlawing of bastardy by the Status of Children Reform Act, and how women were treated in this country with reforms to the Family Law Act. But those were the 70s, Mr. President. We went through another iteration, and it seems that it's only when the Barbados Labour Party is in government we take a look at the law of Barbados in a robust way, and that is important. We cannot stand still, and there's a tendency in Barbados to see no good thing before or after 1966, and that we are caught in a time war because we are moving too fast, we're changing this, we're changing that. But Mr. President, we live in a world where we have to deconstruct almost everything that we stand on because we have to continue to be relevant in the world that is to come, the world in which we live. And we have to examine our legal framework within this view because the system that, for example, we changed our Education Act in 1981 in order to eliminate a lot of the biases that came out of the education system that was restructured by the Michelson Commission in the 1840s. We abolished the distinction between grammar school. And was it other school? They had grammar school and I was comprehensive schools. But the truth is that we may have abolished it in law, but in reality, the system still exists. So that there has to come a time when we look at our laws and be able to reform them without being fearful, because in that process of deconstruction, it is necessary to evaluate the things that are good, that we need to keep, and we also need to be able to build up the ramparts and foundations for the wars and the journeys that we have to travel in the future. And to say to the country, Mr. President, that we will take a stance and draw a line in the sand that we're not changing any laws or anything to do with the laws of our land is to condemn the future generations to a past. When in fact we know that all of the research tells us that in 20 years' time, Mr. President, 3/4 of the jobs that will be available for young people in 20 years' time do not know exist. So this reluctance, Mr. President, to deal with reform in a very robust way is something that I cannot support. And I therefore will be able to commend the government for the approach to putting this law reform and law revision commission on a strong statutory basis, on a strong corporate basis that would allow it the flexibility to be able to hire expertise and services that would allow Barbadians to have that robust intellectual approach to the building out and refashioning of our laws. So, Mr. President, with those few words, I'm obliged to you, and I have great pleasure in supporting the amendment before the Senate. Thank you.
Thank you very much, Senator Nichols. Senator Andre Boyce.
Thank you, Mr. President, for recognizing me. I certainly want to echo many of the sentiments expressed by the speaker who preceded me in this debate, sir, but I thought it important to join the debate because I wanted to spend a moment or two, given the late hour, ruminating, if you will, on the social utility of legal reform, sir. Sir, we all appreciate the extent to which law sets the normative standard in a society. It tells us who a society is. It tells us who the inhabitants of that land can be. And, sir, our considerations of law reform in this moment cannot be divorced from the history of this country. We have heard time and again in this chamber today that this was the parliament from which, in which the slave code was passed. It was, and we appreciate that that code was the architecture of the atrocities endured and survived by our ancestors, Mr. President. And now it falls to us as a former colony, as 57 years post-independence, as a new republic, to refashion the laws of this country, to look at the atrocities of the past, sir, and try our very best to create a more capacious understanding of our democracy, Mr. President. To look at those previously excluded and say that the Barbadian project includes you too. And I think that is the context in which I want to place this debate, sir. Because while the amendment appears to be a mere administrative matter, it is about giving the Commission the ability to refashion our laws, Mr. President, to consider developments and, like I said, to include the previously excluded. Sir, in my view, the Law Reform Commission deepens the bench of democracy in this country. I pay particular attention to the suggestion, and you permit me if I refer to my notes, the part of the aims and objectives of the Commission that says that the Commission will accept and consider the proposals and suggestions of Barbadians, Mr. President. Senator Nichols talked about the extent to which laws in this country, many laws in this country, remain from the Victorian era, sir. We have had in this country an architecture of child protection and child justice that is 100 years old and goes back to the time when the relationship between the state and the citizen was one of subjugation, sir. And then there's the example of persons with disabilities who in the history of this country have never had comprehensive legislative protections. And the Law Reform Commission has participated, well, let me first say, as many of you are already aware, that both those matters, the issues of child justice and child protection and the issues of disability, are properly on the government's agenda, sir. And the Law Reform Commission has participated significantly in the development of those modern pieces of legislation, sir. And I hope I do not trespass on the rules to say that when they are considered in this House, that my heart as a young Barbadian, a young Black person with a disability in this House, my heart will sing, sir. That is the social utility of a Law Reform Commission. So this is not just an administrative matter. It isn't just an academic matter. It is about how we make this country just and even more just still. And with those words, Mr. President, I'm obliged to you.
Thank you very much, Senator Andrea Boyce. Senator Cummins.
Thank you very much, Mr. President. I want to acknowledge the honourable senators who have addressed the chamber and who remain engaged on this topic. I know that the hour is late, but I want to thank each and every one of them, starting first with Senator Watson for her recommendations on enhancements. I want to take the opportunity in responding to the honourable senator to make it known that the Office of the Attorney General has very much been engaging on perhaps some of the things that you have recommended already as part of the work of the Law Reform Commission, part of the work of the Office of the Chief Parliamentary Counsel, and part of the work of the overall Office of the Attorney General, and that it is the expectation that we will see the kinds of outcomes to which you have already referred. Senator Nichols, in a comprehensive contribution, I think we are in no doubt as to why he sits as a commissioner on the Constitutional Commission, looking at the reform of Barbados' constitution overall and the role that he continues to play in treating to the Barbados legislative frameworks as well as our reform agenda, and I want to express my appreciation to him for that. And then finally, Senator Andrea Boyce for his contribution on how the Barbados Labour Party and this administration has been not only a champion, following on from Senator Nichols, of law reform and legislative updating of a comprehensive suite of laws, but also how we have also been the party to originate and to introduce an entire suite of proposals on treating to persons with disabilities who constitute those of the communities that the Barbados Labour Party and this government is committed to supporting. And so, Mr. President, I want to take the opportunity finally to say that on questions relating to financing and funding of various institutions, the estimates of expenditure were very much laid just yesterday. And so the estimates that are before us now, the printed estimates are not here by happenstance, but they come as a consequence, Mr. President, of the estimates having been laid just yesterday. And I can give the assurance that captured in this document and coming from the other place over the course of the coming weeks, we will have every opportunity to discuss the question of government's financing of the institutions of the government of Barbados. And with these few words, Mr. President, I beg to move that this bill now be read a second time.
Thank you, Senator Cummins. The question is that this bill be read a second time. Will all honourable senators in favour please say aye? Aye. Those against please say no. I think the ayes have it.
Mr. President, I beg to move that Your Honour do now leave the chair and the Senate resolve itself into a committee of the whole for further deliberation on this bill.
The question is that I do now leave the chair and the Honourable the Senate resolve itself into committee for further consideration of this bill. Will all honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it.
The Senate is now in committee.
Clause 1.
Madam Chair, I beg to move that Clause 1 do now stand part.
The question is that Clause 1 do now stand part. Oh, will all honourable senators in favour please say aye? Will all honourable senators against please say no? The ayes have it.
Clause 2.
Madam Chair, I beg to move that Clause 2 stand part.
The question is that Clause 2 do now stand part. Will all honourable senators in favour please say aye? Those against please say no. The ayes have it.
Clause 3.
Madam Chair, I beg to move that Clause 3 stand part.
The question is that Clause 3 do now stand part. Will all honourable senators in favour please say aye? Those against please say no. The ayes have it.
Clause 4.
Madam Chair, I beg to move that Clause 4 stand part.
The question is that Clause 4 do now stand part. Will all honourable senators in favour please say aye? Will all honourable senators against please say no? The ayes have it.
clauses 3 through 7.
Madam Chair, I beg to move that parts 3 through 7 do now stand part.
The question is that clauses 3 through 7 do now stand part. Will all honorable senators in favor please say aye? Those against, please say nay. The ayes have it.
Schedule.
Madam Chair, I beg to move that the schedule be the schedule to the bill.
The question is that the schedule be now the schedule to the bill. Will all honorable senators in favor please say aye? Those against, would you please say no? The ayes have it.
Madam Chair, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Will all honorable senators in favor please say aye? Those against, would you please say no? The ayes have it.
The chairman has reported to me the passing of one bill in committee.
Mr. President, I beg to move that this bill now be read a third time.
The question is that this bill be read a third time. Will all honorable senators in favor please say aye? Those against, please say no. The ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Law Revision and Law Reform Amendment Act of 2024.
The question is that this bill will now pass and be cited as the Law Revision and Law Reform Amendment Act 2024. All honorable senators in favor, please say aye. Those against, please say no. The ayes have it. This bill is now passed and so cited.
Order number 4, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Transport Authority Amendment Bill 2024.
Senator Cummings.
Mr. President, I know that the hour is late, and I see the looks of some looking at me to see if I'm going to do this bill. But, Mr. President, we are here to do people's business, and the government of Barbados will do the government's business. And so we are going to push through the agenda and finish the items that are on our order paper for today. So, Mr. President, this is quite a simple amendment. There are two amendments that are being contemplated in this draft bill. Mr. President, well, two substantive amendments. One, Mr. President, it attempts to create a definition in the first instance for what constitutes a license for the purpose of the application of regulations under the Barbados Transport Authority. Mr. President, I will not spend any time tonight talking about the public service transportation system because it has been well articulated, well ventilated over many years. When I spent some time in preparing for this debate today, Mr. President, I was able to go back as far as 2011 and before 2007 and before then to where these issues in the public transportation system originated. I was able, Mr. President, to be able to go back into the draft of the history all the way back to the original Transport Authority Act, Mr. President, from in 1955. We know all of these things. We've talked about them ad nauseum, for sure, Mr. President. I'm sure that perhaps I may be the only person who had to depend on the established print media to see a viral video circulating just this week of PSVs behaving in the way that we have talked about PSVs behaving for an extended period of time, certainly a minority and not a majority, but too many is, one is too many, and we want to be able to bring order to the road. So in simple, In simple terms, Mr. President, what the government has sought to do is to empower the Barbados Transport Authority to be able to deal with the management of PSVs on the road. The attempt, Mr. President, to limit the role of regulation for the purpose of the PSV sector, or to expect that the Barbados Police Service and the court system will be in a position to respond in a reasonable time frame, given all the other things that are being navigated, to be able to bring order to the roads is not a realistic one. And so the government of Barbados has made an undertaking that there will be some accountability given, one, not just in the first instance to PSV drivers and conductors, but also to those who own PSVs to hold them accountable for the vehicles that they have placed on the road. So in simple terms, Mr. President, what is being asked for in this legislation is, one, for there to be a definition provided in the first instance of what is a license, and to have that license revoked where applicable by the operation of the Barbados Transport Authority. This bill has been in place, or this legislation has been in place for some time, and the regulations are going to be accompanying it, and we are making the necessary amendments here. So in the first instance, Mr. President, license in this instance for me, for many of us in this room, relates to that blue document piece of card that we have in our purses that tells us that we passed the driving test and we're empowered to drive the motor vehicle, whether light goods, private car, automatic, whatever it is. For the purpose of this legislation, however, the definition has the following meanings: a license to drive a public service vehicle, motor, omnibus, minibus, or route taxi issued pursuant to section 23(1)(a), or a license or authorization to act as a conductor on a public service vehicle, motor omnibus, minibus, or route taxi pursuant to the same piece of legislation. And so in this instance, the guidance coming from the Office of the Chief Parliamentary Counsel is that you did not want to use the ordinary meaning of the word license, but you wanted to make it specific in this instance. We also had the circumstance, Mr. President, where the role of the Barbados Licensing Authority, on the one hand, was enabled to provide, revoke, or cancel licenses as defined up above, but the role of the Barbados Transport Authority had a different, it did not have that authority. This legislation allows them to take full control over the operations of the entities operating as PSV on the roads to be able to bring some order. And so what we have before us, Mr. President, would be Transport Authority Regulations of 2024. And we have that there are a number of things that are being incorporated. One of them is the one I have just outlined. We have the regulations dealing with owners, which were inadvertently excluded in the last discussion. And the regulations, therefore, allow for us to be able to deal with those things. But then finally, Mr. President, because the government does not want to be in a position where it is passing laws, where it is making regulations, where its agencies are functioning in a way that people are not clear, the Ministry of Transport and Works has committed that it is their intention that the draft regulations, which have been approved by Cabinet already, will be accompanied by a public education campaign that will be rolled out once they are in a position to have all of the amendments approved and passed through this Honorable Senate. And so it is my hope that, as is the intention of the Ministry of Transport and Works, that all persons sitting here under the sound of my voice in this honorable chamber will be able to identify with the amendments that are being proposed, the purpose for which they are intended, and to be in a position to support this bill before the Honorable Senate this evening. And with those, again, very few words, I beg to move that this bill now be read a second time.
Thank you, Senator Cummins. Any speakers? The question is that this bill be read a second time. Will all honorable senators in favor, please say aye. Those against, please say no. I think the ayes have it. Senator Cummins.
Mr. President, I beg to move that Your Honor do not leave the chair and the Senate resolve itself into committee for further deliberation of this bill.
The question is that I do not leave the chair and the Honorable the Senate resolve itself in the committee for further consideration of this bill. Will all honorable senators in favor please say aye? Those against, please say no. I think the ayes have it.
The Senate is now in committee.
Clauses 1 through 4.
Madam Chair, I beg to move that clauses 1 through 4 do now stand part.
The question is that clauses 1 through 4 do now stand part. Will all honorable senators in favor please say aye? Those against, please say no.
Madam Chair, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Will all honorable senators in favor please say aye? Those against, would you please say no? The ayes have it.
The chairman has reported the passing of one bill in committee. Senator Cummins.
Mr. President, I beg to move that this bill now be read a third time.
The question is that this bill be read a third time. Will all honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Transport Authority Amendment Act 2024.
The question is that this bill do now pass and be cited as the Transport Authority Amendment Act 2024. Will all honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it. This bill is now passed and so cited. Senator Cummins.
Mr. President, that brings us to the end of government business for the day. I want to acknowledge the contribution of every honorable senator who has spoken. We also had a number of guests with us today, and I want to also acknowledge the presence here earlier during the evening of the representatives of the labor movement who were here to be able to be a part of the passage of an earlier bill. And so with those words, Mr. President, I beg to move that the Senate now be adjourned sine die.
The question is that the Honorable Senate be adjourned sine die. Will all honorable senators in favor please say aye? Those against please say no. Methinks the ayes have it. The Senate is adjourned sine die.